guess I better find out about that. And compare it to the one they did. There's a smirky smiley face on the one on 2106. I don't see that on number 2, so I'm not sure how that arrived.
Wait a second. So, can you make 2116 a little bit bigger for me, please? What is this red comment?
This is our follow-up to production from Sally Smith, and that appears to be a statement by her counsel explaining why the first disclosure didn't have that message.
Now, Ms. Crowells, what are you saying is not correct? I'm not.
So number 2 on 2116 has the statement, the text. If you look at 2106, they added a smirky face.
That's the wrong.
That's not.
Where's the 1508? You say it's number 2?
Number timestamp 20, yeah, it's from 10/18/16.
2:08 p.m.
You see the text.
1508.
Not sure about court. I guess I better find out about that, is the last comment.
Well, Mr. Whitney, Ms. Crowells is correct that your summary sheet has an emoji that.
Yes, Your Honor, I see the discrepancy, but that's not, just to be clear, that's not our summary sheet. That is from Smith's counsel. We did not create the emoji.
Well,
Here's, I hate to say this, but if you're going to use a summary, it's got to be accurate. And if not, we're going to use the original, but you then need to redact the comments.
and the personal phone numbers, Judge.
We're prepared with redactions, I'm sure. We have the redactions prepared to the one you're looking at on the left, Your Honor.
Okay, so have you shown that to the other side so they've had an opportunity?
It was sent to them this morning with the redactions. I'm sorry?
This morning to add to the system. I don't know who's saying.
How in the world are they supposed to, I mean, I had them here at 8:15. If you sent it to them this morning, how are they supposed to have time to compare what you sent to the original?
What I'm answering for.
How many problems, Ms. Crowells, are there with the 2106? Is it just that one where there's...
No, there's another one at 0804, 10/19/16. There's another emoji. I didn't, honestly, Judge, I didn't do side by side every line comparison because I just didn't. But that's what stood out to me just looking at it now. And yeah, I didn't do it line by line.
Fastest way to address this would be to fix 2106. However, you're correct that technically the better one, the best evidence is this other one, which I guess is 2116. So.
Can I suggest, I don't know what witnesses would possibly be used with today.
Mr. Kowalski.
Well, Judge, I don't know how they...
To comment on text between two doctors that weren't sent to Mr. Kowalski?
To comment on the concealment of the videotaping of his daughter and how he his daughter was being put in a room for 48 hours.
Well, Judge, they can ask them that without.
Yeah, I don't see how you're using a text message between one doctor to another doctor with Mr. Kowalski. I agree that you're going to be able to use these text messages, but the format you've got them right this second isn't ready.
Understood.
There's really only about 5 lines out of this whole thing that we,
The exhibit is not ready. That's on you. The exhibit's not ready. So let's go on to the next one.
and can we get on the record exactly what we need to do to
You need to make sure that the summary is identical to the content of the original, or the original needs to be redacted to remove Mr. Haskell's comments
And the personal phone numbers, Judge.
and the phone numbers.
understood?
Well, it needs to be redacted for part of the phone number, but they need to be able to show. Can you pull it back up, because I don't remember if the name.
It says the name, Judge. It says
does.
Sally Smith, Qualities. It says the names, and then it has their phone numbers after that.
Okay, so long as there is no doubt who it is. Okay. So,
We will get them the accurate copy and address it another time.
what's next?
What's our next exhibit that we need to?
Explain us what's next.
Well, we're not calling Kirkpatrick or Hannah, so hold on.
I guess we should get, Mr. Whitney is locating the exhibits, and I'll explain why. Last night, I had the chance to see Dr. Kirkpatrick in person, and he is definitely not well and in no condition to go on the stand. I texted counsel earlier this morning on that. There's nothing I could really do about it. I had Dr. Henschke coming in at the same time, and so we made a judgment call that we are not going to call Dr. Kirkpatrick today. We are going to continue with Jack Kowalski, and then we want to play the deposition of Rebecca Johnson, and then the deposition of Kathy Beatty. And then we would like to put Dr. Henschke on, since she is here for her timing, and we had notified counsel before. However, again, as we expressed to the court and to counsel, we are running, just because of the way things go, we're running about a day late, or earlier, excuse me. And so we are moving people up and deciding who to call and not to call for 2 reasons, Judge. First, the people flying into town, example, Dr. Cantu today for tomorrow morning, which counsel knows about. Dr. Henschke had originally been scheduled to go on
Can you just tell me what you're asking me?
to move Dr. Henschke from later tomorrow afternoon, up to later this afternoon.
And the issue is they weren't told about it until when?
They were told about it this morning,
No.
so she goes tomorrow.
Well, I don't know when she's going, but she's not going today.
All right, well, she's scheduled, but okay.
If you didn't tell them until today, we have to give some minimum level of due process here. So let's please, I appreciate that scheduling is a nightmare, but you can't just drop a doctor on them the morning of.
I understand, Your Honor. Had I been able to ascertain the facts and make a decision, I would have texted them, but it really wouldn't have made any difference, because it was 11:30 and 12 at night, and I didn't think that they were still up and intending on, even if they could, they would want to stay up and prepare for Henschke. So I kind of figured this would happen, but I have to ask because I don't want any holes in our case.
Well, I have ruled on about, 12 or 13 depositions by now, even maybe more. Hopefully some of them are cut and ready to go.
We've got Beatty and we have Rebecca Johnson. We're going to play Rebecca Johnson first. As to Kathy Beatty, it is recut. The only thing that's left after the court's notations and sustaining of objections is for counsel to review it, to ensure on those highlighted portions that the court had concerns with, that we had properly edited it. I don't anticipate, just having flipped through it, that would take longer than a half hour. If counsel can spare one of their many attorneys to flip through that over the course of the next hour or two, then Beatty will be ready as well, and that'll take up most of our afternoon.
Judge,
Could I
go ahead.
So neither Dr. Kirkpatrick or Dr. Hanna are coming today?
I have not been able to finish preparing Dr. Hanna because of all the hijinks yesterday, and I do not intend to put a witness on the stand until I've had the opportunity to do so. You know, we're already working 18-hour days, so there's only so much we can do, and these doctors take a long time. We started prepping them before trial, obviously, going through the records, doing everything we're supposed to do, but this is reality.
Okay.
You know?
So, what you're telling me is you got Jack Kowalski and then a whole bunch of videos.
Yes.
Now,
2 videos.
2 videos. That's fine, but with the videos, probably some paralegal could be looking at because there's rulings and it should be a.
We've looked at the Rebecca Johnson one, Judge. That's ready to go, is my understanding. We have not, didn't know until this morning that they didn't get us Kathy Beatty's. Did you give it to us?
I don't know, do we have?
The actual, we can't view it unless you've sent it to us.
Get it, I can get it to you.
Okay, so we haven't had the video to view, but they're going to get it to us this morning, so maybe over lunch. It's a little difficult to do it during the court, but at lunchtime, we will look at Kathy Beatty.
I can understand that, but perhaps somebody can go into one of those witness rooms and watch it this morning and just compare it to
Right, that will.
the court's rulings.
Yes, we'll make sure that happens, Judge.
I think that's a fair request.
Yes.
Okay, so we're going to finish Mr. Kowalski, and then we'll have a couple of videos today. Tomorrow is Cantu
Yes, sir.
and whom?
Henschke.
Henschke.
They've both been planned for a long time. We've informed counsel.
Well, the only reason I mentioned this is because they had asked for Dr. Jennifer Katzenstein tomorrow. I need to tell her now if they're not planning on calling her.
Is she the one coming from the Panhandle?
No, she's local at All Children's, but she booked her schedule off. If they don't plan on calling her, I'd like to let her know now that she's released.
Okay, well, that's dependent on what the court decides on doing with Maya Kowalski's disclosure. Because she wrote the psychological note in the hospital that shows it's in their record. So it doesn't make sense. We were told also in the motion that she's on a Disney cruise, so.
She came back from the Disney cruise Monday morning. She is planning on being here tomorrow to testify at their request.
And
It's first we're hearing that.
Okay, so do you want to deal with the motion now with respect to Maya Kowalski's?
Yes, Your Honor.
yes, Your Honor.
Okay.
We also, there are, and we can speak to them, mentions of this in Dr. Henschke's file as well. And have we provided the court with that yet?
We can pull it up.
All right. And we can show the court in just a moment what they are. When Dr. Henschke came in last night, we started at least to talk to her and let her know what was going on, and made her aware of this, and that's how she brought to our attention that she had some notations of a similar type in hers, if the court wants to see them.
Well, I'm not sure just seeing more of the same is an issue that we need to deal with right this second. Okay. I have read the motions in the response to the parties wish to add any further argument.
On behalf of plaintiff, Your Honor, there is no signs or indications, and nor would I as an officer of the court ever misrepresent my knowledge of this. It is a well-known psychological phenomenon, the court's familiar with that children often suppress these things. It was revealed in 2 ways. One, to Dr. Katzenstein, and now I learned there's a similar type of comment in the Jackie Henschke records. as soon as we knew about it, we did the right thing, which was to confirm, before we raised something like that there was confirmatory testimony and knowledge, which we did with Jack Bertram. In this instance, I think the goal should be the truth and that the jury should have all of the information. This case has been about Maya being assaulted or battered since the very start of it, and there have been allegations raised. I would point out, Your Honor, that upon receipt of the response, we did the timing upon receipt of the response to our subpoena ducis tecum for the Henschke records. The defense began, from our notes, really pushing in earnest for any mention of sexual misconduct to be excluded. And I'd like to know from counsel whether they had identified something that I candidly did not, because I didn't even expect to call her, if the court recalls. But I'd like to know from them whether they had spotted back in response to the subpoena ducis tecum those notations as well. I have the belief, although I'm not accusing counsel of anything, but I have the belief that their knowledge was far earlier than this, and the hope was that Maya would keep it in, or that we wouldn't notice some of these notations, which admittedly are oblique in some circumstances, though Henschke's is much clearer. And so if in fact they had this knowledge from the ducis tecum and otherwise, then they had advance notice of this, and the fact that they have pursued so aggressively excluding any type of reference whatsoever with Beatty as the focus is curious to me. In this instance, I would think that if you need, we've got the Katzenstein record is already in as a joint exhibit, so there is some evidence within the record without objection to that. So in this instance, having Maya Kowalski expand on what we already know, which is her belief that some of the actions of Kathy Beatty were of a unusual nature towards her, we believe that there was more than adequate notice and that it should go in. Typically, the final thing I'll say is typically in trials, new facts come up in every big trial. And typically the pleadings collapse into the proof at trial because it's impossible to plead every single fact in the complaint, nor even in an ultimate fact pleading state is it required to plead every fact. So we would move the court pursuant to our motion to allow that in.
Judge, I'm only going to address the comment about the accusation regarding the defense attempts to remove the spurious allegation of sexual abuse by Kathy Beatty, since I was the one that was addressing that. The only allegations in the complaint regarding any type of, quote, sexual battery, end quote, were against Kathy Beatty as her former counsel when she was a member of this case. I immediately began trying to address that because there were no factual allegations to support that anything Kathy Beatty did was of any type of sexual connotation. And that was the basis for all of those motions to try to get that stricken, which the court granted as far as motion in limine in regard to those type of unfounded accusations regarding Kathy Beatty.
And the motion, Your Honor, is basically a motion on an issue of law, whether they're entitled to bring this up in a situation where they have already admitted they didn't plead this. In the effort to try to specify better what the false imprisonment claim was and what the battery claim was, that they've laid it out. And their battery claim deals with Ms. Beatty in various places in the hospital and with other nurses and social workers in and around the 2-day period involving the EEG room. That's the battery that we came here prepared to try as a matter of due process. And now they're wanting to bring this in. The notion that they can bring this in as something under Rule 1.19.190B, this has not been tried already by express or implied consent. And this is otherwise something that simply cannot be brought up at this time on these pleadings. So if you have additional questions about what we've submitted, that's fine. I don't think we need to go into the facts, but I know that Dr. Katzenstein has a very different explanation for her note.
The court has before, or Mr. Anderson, were you going to say something else?
Typically, we're talking about one incident here, Your Honor, and typically this is handled through cross-examination by pointing out that some of the incidents that the plaintiff testifies to in trial are different than those in the deposition, and they're impeached on that basis if that ends up being the case. I would finally point out that the Katzenstein records went in without objection, and if we are in fact true, if our allegations are true, then there was no objection, and that allegation went in without any effort to clarify that or otherwise. So there's no prejudice here if, and as it appears from at least two independent sources of records, that there was any true prejudice.
The court has before plaintiff's motion to admit newly discovered evidence or alternatively to amend the complaint, which is at docket identification number or DIN 3444. The response actually was docketed before at DIN 3443. That has to do with how the clerk docketed when those were filed over the weekend. The genesis of plaintiff's motion has to do with what is clearly a late disclosure by Maya Kowalski. That disclosure became known to the court and to the defense counsel during the trial. That was after the jury had already been sworn. We had already conducted oral argument, opening statements, and started with witnesses. The court will assume, for the sake of ruling on this motion, that Maya Kowalski's statements are correct, that there was some type of sexual incident that occurred while she was at Johns Hopkins All Children's Hospital in October. The question is, given where we are right now in this trial, what are we able to do, if anything, about it? The plaintiffs reference the Binger case, but Binger really is talking about undisclosed witnesses, not an amendment to add new claims. We also have a rule that allows for pleadings to be amended for items that were tried by express or implied consent. Clearly, the defendants are objecting to try an issue that was not part of the pleadings, and it clearly was not part of the pleadings. So we get down to a fundamental due process issue, which is notice. The whole point of having the pleadings is to explain the conduct that the plaintiffs are accusing the defendants of engaging in, so that the defendants can prepare and defend against those. And it's just a simple concept. It's notice. Here, we did not ask questions of the jurors about sexual assault. That would have been a major focus of individual voir dire by the court and the parties had we known about Maya Kowalski's disclosure. We would have asked those jurors. Some of those jurors may or may not be seated here today, but we wouldn't know and have no way of knowing because we had no opportunity to ask those questions given the late disclosure. So I do not see how we can try the issue of a alleged sexual offense, again, assuming that what Maya Kowalski says is true. The ability to amend pleadings, even if you can amend pleadings during trial, and I'm not sure you can unless there's consent, but to amend pleadings, we look at a three-pronged test. One, would it be futile? Well, clearly, if Maya Kowalski's allegations are correct, it would not be futile, because as the plaintiff suggests, they want to bring a battery and a negligent security claim. Is there an abuse of the amendment? Well, we're on number 8, so that's probably a jump ball at this point in time. But the third prong is prejudice. And here the prejudice to the defendant is more than palpable. It's extremely palpable, because how are we able to try an issue when we haven't even asked the jurors who are seated on this jury about their views of sexual assault? So I don't see how we can do it. So we're now down to the question of, are the plaintiffs moving for a mistrial at this point in an effort to seek to add this in? Now, before you answer that question, let's think this through, Mr. Anderson. Assume for the sake of argument you wanted a mistrial, and I granted it. You added a count for battery. Assuming that the defense would be able to identify the individual, since what you're alleging is effectively criminal conduct, we're now going to be confronted with a Fifth Amendment invocation, most likely, by the individual who Maya Kowalski would be accusing of this sexual assault. With the invocation of the Fifth Amendment by that individual, that might mean this entire trial, if we granted a mistrial now, might then be suspended. I don't know if your client has made a report to the St. Petersburg Police Department for this sexual assault. I don't know if that's forthcoming. And if so, whether the state attorney would investigate it. I don't know what the statute of limitations is. I don't know what would be charged. I don't know the fact that she was a minor. So it is an entire panoply of issues that, if you add a battery count for this issue, is not a very neat and clean, oh, let's just bring it back. Perhaps that's why you were talking about negligent security, but at the same time, you're still going to have the same issue relative to identifying the individual who did it and possibly having a Fifth Amendment invocation that would delay. So I'm going to deny the request to admit testimony by the witnesses on an issue that was not raised in the pleadings. And again, this is not that I don't believe or do believe, because for purposes of my motion ruling, I am assuming that what Maya Kowalski is saying is true. It's just how this was presented in the middle of trial is the prejudice is so severe that there would be no way we could continue with the trial in this posture, and we would have to go to a discussion of a mistrial. So I'm denying the motion to admit the evidence, and I'm denying the alternative motion to amend the complaint. So at this point, the question is, do the plaintiffs wish to move for a mistrial?
Obviously, we would need to consider that, Judge. We have begun considering it. I believe that the court, and would ask the court to withhold final on this and allow us to at least bring in Dr. Katzenstein so that you can hear a proffer on that. And then if we can bring in Dr. Henschke and the court can hear a proffer on that, because I understand about the prejudice. What if the court concluded from the record that after the subpoena ducis tecum to Dr. Katzenstein and receipt of those records, that the court saw a marked increase in the amount of motion practice to exclude this? And the best way to do is ask as an officer of the court to them as whether after receipt of the either review of the Katzenstein notes or after receiving the Henschke notes, which I'd like to at least show the court, then if in fact they had that notice, regardless of whether we had picked up on it or not, because our client didn't tell us about it, and frankly, it wasn't something we were searching for here. If in fact they knew through this and chose tactically not to raise it, knowing that there's a possibility, as every good trial lawyer does, that things come out at trial, the court might reconsider this. I am adamant that any good trial lawyer having some notice or idea about this, in reading in particular the Henschke records, would be aware, given our allegations against Ms. Beatty in this regard, would be aware that that issue was out there. And careful trial lawyering, both sides, careful trial lawyering on both sides is to the effect that you plan for things that could come in as well as things that you don't think are going to come in but possibly could come in. And so I beg the indulgence of the court. I know you've spent a lot of time on this, but I beg the indulgence of the court to hear us out with some of this testimony. And what that would entail would be hearing from Dr. Henschke on it, hearing from Dr. Katzenstein on it, and questions as officers of the court as to counsel about the unusual nature of the increase of motion practice about sexual misconduct after they received the Henschke records. I'm not accusing anybody of anything, but these are the facts.
The reality, though, is one, it's still not in the pleadings, which is a huge due process issue. And two, we did not ask the jurors any questions about what, and I'm telling you, having sat through many sexual assault trials, is a huge issue, and it's a fertile ground for cause challenges of jurors. And so there is no way that you can cure that prejudice by any sort of statement. Well, they knew about it even though we didn't tell them about it. So your remedy would seem, there's always, if you think there's a fraud on the court, there's remedies you can engage in for fraud on the court. But at the end of the day, there is no pleading that supports this claim, and we did not address this issue in front of the jury. And I don't see how, even if you wanted me to wait for a further evaluation of information, how those two fundamental issues would change one bit. And those things cannot be changed at this time. So we're down to the question of, is there a mistrial motion or not?
Well, I can't make that call until I have a moment to talk to my client, obviously. We weren't sure of the court's ruling. I do also want to pull the transcript of the voir dire at the start, because we wanted to ask questions about this in terms of Kathy Beatty. The defense objected vociferously on it. And so it was not a situation where the issue of that was just out of the blue. We had already raised that with Kathy Beatty, and my memory of that was that the defense was adamant that we not talk about that in front of the jurors at all. The court ultimately agreed, but that's not necessarily our fault, because we foresaw that there were possibilities at this trial that Kathy Beatty would come forward in this regard. And so again, we want to make our record. I understand the court's direction. When would you like me to ask my client, and what do you want me to do?
Well, we're about 3 minutes before having the jury come in, so obviously right this second it's not. But I see no reason to spend a lot of time and energy going forward if, one, you make a mistrial motion, and two, I grant it. I'm not saying I would grant it. I'm just saying I need to understand what you are moving for, if anything. The reality is, and that's why I put it out there about what would happen if you amended the pleadings to add a battery count, because I think you're going to run square into a Fifth Amendment issue. But hey, it's not my complaint. I'm just the guy calling the balls and strikes. But I do think it needs to be said that the issue with Catherine Beatty had to do with the allegation that Miss Beatty placed Maya on her lap when she gave her a hug and things like that.
Kistner.
It was not in the realm of what you're talking about in this allegation by Maya Kowalski with respect to the white slender guy with the lab coat that we see in the records that you are referring to.
As to the,
And let me, because I've been letting you talk. I see Mr. Altenburn trying to say something, so let him say whatever he needs to say.
In light of the accusations that have come from the other side here in this public courtroom, I just want to state, as I think you have just explained, that my motions addressed to the issue of battery of this context were directed solely to that of Ms. Beatty, and it was based on the fact that we had taken depositions from Maya Kowalski and done various other discovery, and there was absolutely no evidence to have based an allegation in a complaint on a claim of sexual battery under the definitions in Florida law. So nothing of this was done to hide any evidence that we knew about at any time before this came up the other day.
Are there anything else we need to address before this jury comes in?
I wanted to announce that neither Kelly Perry nor Jennifer Anderson, counsel was concerned about their type of illness. They both took COVID tests and they're negative. Do you have any other exhibits we need to talk about?
The only question I have, Judge, is a practical one that Your Honor made reference to. If there is to be a motion for mistrial, when might we expect a decision?
Well, I'm not going to let this carry longer than today. It's going to be resolved one way or the other today now. I still think we need to cut the videos. I still think we take the testimony from Jack Kowalski. It's just we're not going to get into this newfound allegation by Maya Kowalski with respect to that alleged sexual abuse.
Very well, Judge. Thank you.
Anything else before we bring in the jury?
I don't believe so, Your Honor.
Let's bring in the jury. Please be seated. Members of the jury, I want to confirm while you're away, you did not discuss this case amongst yourselves. You did no investigation, and you did not receive any information about this case. Is that all correct? And I want to confirm that since you left us last, you have not been approached by anyone about this case. Is that correct? And I want to confirm that since the last time you were with us, that you have not seen any media accounts of this proceeding. Is that correct? Okay. I have been handed a note by one of the jurors about November 2nd, and when we will know for sure. Let me tell you where we're at on November 2nd. I am on a statewide committee, and that is a day that I am actually supposed to be chairing a meeting in another county. We are ahead of schedule in this case. I feel November 2nd at this point in time, we don't really, I think we can probably safely call it, saying that you will not be here on this day, because even if we slow down, I still think we can still get you plenty of time to deliberate before that November 8th date that I told you about in jury selection. So from my perspective, I'm going to make the command decision now that November 2nd will not be a jury day. So for those that need to keep their medical appointments on that day, let's go ahead and keep those medical appointments.
Thank you.
Okay. Mr. Kowalski, come on down, sir. We're going to re-swear you since it's been overnight. Ask the clerk to please swear you.
Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Welcome back.
Thank you.
All right. When we were talking yesterday, you were attempting to, I believe, leave on that Sunday the 9th. Is that right?
Yes.
I'd like to show you what's been marked in evidence as Exhibit 1001-0063. Permission of court. It's in evidence. May I publish it?
If it's in evidence. I'm sorry?
It's a vote. Progress note. All right. If you would, please read down through particularly the second paragraph in the top half. And we're going to highlight a couple of phrases there. As you can see, the first sentence, and I then discussed with Michelle Smith, and did you understand Dr. Smith to be a doctor there at Johns Hopkins?
Yes.
Would be a discharge against medical advice, as we have not completed a wean of therapy, and Dr. Sally Smith has not had the opportunity to evaluate the case. Do you see that?
Judge, I object to the leading, and again, this is reading of the medical records.
But I can't.
We're not reading medical records.
All right. Were you ever informed that there was a goal of keeping you there based on a statement that it would be AMA, when AMA is not a legal basis for keeping someone in Florida with in these circumstances?
I object to the leading. It also calls for a legal conclusion.
Yeah, I'm going to overrule those objections. You can answer that question.
I'm sorry, if you could repeat it.
Sure. Were you ever informed that the hospital had been considering ways of how to keep you there, you and your family there, simply on the allegation that leaving would be against medical advice?
Oh, we weren't.
Object to the leading and the speculative.
He just overruled that.
Overruled. You can answer.
Can you?
We were told if we left, we'd be arrested. So
Did they let you know there that they had really no right to keep you?
they had no right at that time, no.
And your concern, if you left, would be, or tried to leave, what did you picture happening to you and your family?
I don't think we would have made it out the door
And why was that?
because we'd be arrested, like they said.
Now, down in the third from the bottom line there, it begins with "there is." Do you see that?
Mm-hmm.
And so at this point, the best of your knowledge, was there any Department of Family and Children legal obligation or reason to be able to hold you?
No.
Again, object to the reading of the medical record. Your Honor.
That question is allowable, but you might need to re-ask it, given that.
What, if anything, did they tell you about whether DCF could hold you there or not hold you there?
They didn't tell us anything.
Did you, of your independent knowledge, know anything about the law as to DCF holds or procedures?
Not at that time, no.
Looking down there, if you look at the next paragraph, beginning I spoke with, and if you go down about, looks like 6, 7, 8, beginning throughout the ongoing administration. Okay, and so do you see, did Maya's pain remain the same during this period of time, or was Maya's pain increasing or decreasing?
Again, Judge, he's reading from the medical record. We'd just like a question to the witness without, and we would ask the medical record to be taken down.
From what you,
Sustained, and let's take the medical record down at this point.
so did you believe at this point that you were being forced to keep your child in the hospital?
Absolutely.
And did you have concerns whether you yourself or your wife could stay at the hospital, would be forced to stay at the hospital?
Forced to stay? I didn't understand. That we would be forced to stay?
Or was it just simply the Maya?
Well, we wouldn't be able to leave without taking Maya. You know, they stated that we'd be arrested.
And so did it turn out then that you stayed with Maya that night, that Sunday night?
We had no choice.
And the next day, was there a treatment planned to begin to complete Maya's course of the ketamine program treatment?
Yeah, she had a scheduled appointment with Dr. Hanna in Clearwater.
All right. And so did there come a time when you met one of the doctors mentioned in here, Dr. Sally Smith? And if you could tell the jury the situation and what you saw in first meeting Dr. Smith.
The only time that I could recall meeting her was, I believe it was October 13th. I was in Maya's room. She was getting a clean out for a procedure for upper lower GI.
Where were you physically? Were you standing, sitting?
I was taking care of Maya. She was constantly had feces all over, so I was trying to clean her, trying to take her to the little portable commode. There was a nurse
of doing that on her own, or did she?
Absolutely not. No.
Go ahead.
There was a nurse in there, elderly woman. She was assisting me, giving me new washcloths, things like that, sheets for the bed. Then all of a sudden, she walked out, and in walked this woman. It was a woman, black hair, cigarette voice, and she didn't say anything. She's just looking at me while I'm overwhelmed trying to clean up Maya. And she just started asking questions, and the questions really were kind of weird. During that time, it didn't pertain to what I was doing. She's looking around the room.
Were there any introductions from the nurse?
No introductions. And I thought it was kind of rude because here I'm overwhelmed trying to take care of Maya, and there was no help.
Was she wearing a Johns Hopkins? First, do you recognize what a Johns Hopkins All Children's Hospital?
It's a lab coat.
And do you recognize the little signature that
They had the
emblem
lab
on?
coat on, yes.
Can you tell the jury whether she was wearing that at the time?
Yes, there was a lab coat.
And what was your impression from the way that she was introduced or not introduced, and wearing that lab coat and starting to ask you questions? What role did you think she was in at that point?
She's a doctor or medical person within the hospital.
And so what happened after that? You were...
So it seemed like it was coordinated, because when the nurse walked out, the doctor walked in. Doctor left about 10 minutes, if that, and then in walked the nurse again. The nurse said, "You have to leave. Your daughter's under custody, protective custody."
All right. So this was on the 13th?
That was the 13th.
So from the time that you came in on the 7th through the 13th, did the state, to the best of your knowledge, or the hospital have any right to hold you there?
Objection calls for a legal conclusion.
Overruled on that one.
No. We have our right to go wherever we want.
And did you reinforce over that stay that you wanted your daughter out of there?
Many times.
And what was the response when you would say, look, we're leaving, we're out of here?
I think there was a stall tactic at one time. They gave Beata some hope, and that never happened. But then, if you leave, you're arrested.
Did they talk about a transfer?
We were talking about Nemours.
How
That's
was
near our-
it presented to you?
Well, I remember Beata for the longest time wanted it as well, and then I guess the hospital was also looking at Nemours to transfer to the Orlando area.
And what was the reason you wanted, other than just getting out of there, a transfer up to Nemours?
They treat CRPS.
And so then, were you and Beata presented with a transfer form?
Yes.
And what was it explained to you the reason would be why there would be a transfer to Nemours, verbally?
The reason was to go ahead and get her taken there. And the problem was, though, we found out by looking at the insurance codes, it wasn't for CRPS, it was for Mauchausen by proxy. So we did not sign that form, because if we sign that form, we're admitting that we're.
So did the hospital ever tell you that, hey, we're going to send you over there, but we're going to start out with, in their mind, that there was child abuse going on?
No.
Do we have that form we can pull up? Judge, may we publish 3035-0024?
Is it in evidence?
It is in evidence.
Yes, it is.
Madam Clerk, is this exhibit in evidence?
Yes.
Can we say it, please?
3035-0024, the Nemours transfer form from November 3rd, 2016.
The clerk says it's not in evidence.
Judge, none of the defense exhibits are yet in evidence because we haven't presented our case. Yeah, yeah.
It is or is not to? What?
Can we approach?
Sure. Judge, can we approach on that?
Okay, Madam Clerk says that the document actually is in evidence. Certain pages that exhibit. Okay, you may continue, Mr. Anderson.
May we publish, Your Honor?
Absolutely.
3035-024. All right, now, a note, let me get it up here. All right. Is this, it's a two-page document, 024025. Do you recognize this, or did you ever actually see this?
It just came up.
Okay, sorry.
I did not. I'm sure, if anything, Beata did.
All right. And on this record, which is in evidence, as we said, does it appear that Munchausen by proxy is the diagnosis there? Muscle atrophy, bilateral lower extremity, right something?
Yes.
Munchausen by proxy. And who was it assigned by?
Yeah, I object to the predicate on this and the misconstruing the evidence.
Overruled.
Who was it assigned? Who assigned that? You see him right there, right after the Munchausen by proxy, assigned by,
And again, I object to him reading the medical record that he hasn't
just
seen.
directing the witness.
I'm sorry, I don't see where it's
Was
at.
Dr. Dees the doctor there that's shown to have assigned that diagnosis?
Same objection, Your Honor.
Overruled.
The highlighted portion?
Yes.
Yeah. And to the best of your knowledge, Dr. Dees was not a psychologist or psychiatrist that there, was she?
I'm not aware of that.
And to the best of your knowledge, she never performed any type of psychological interview, did she?
Object to the leading.
Overruled. No, she wasn't diagnosed with Munchausen.
So this is on November 3rd. This was the form. Can you tell the jury whether the events leading up to this form began during this period of time that you were trying to leave between the 7th and the 13th?
Yes, it was.
And was this, to the best of your knowledge, the reason that they wanted you to continue to stay?
Oh, yeah. Yeah, we're being held there.
And did they also attempt to tell you that your daughter had to be weaned off of medications?
Yes, that was like the first thing
And-
they stated.
And did you inform them that at no time had your daughter ever exhibited any type of withdrawal symptoms? First, are you familiar with what withdrawal symptoms are, Joe?
At no time we seen withdrawal syndromes for every procedure she went through, including the one in Mexico that was the longest one.
And did you inform them of that there was no danger of that?
We never seen anything.
Okay. And so, did you or Beata talk to the insurance company about the coding on these forms?
I called the insurance company.
And was this in connection with the care and treatment of your daughter?
That's correct.
And what did they tell you?
They gave me the codes and then what it was listed for.
And did that confirm in your mind what they were actually trying to transfer for?
Exactly.
So did you feel misled?
Extremely misled, yes.
Regardless of any of the other reasons, were you trying to get out of there during this period of time?
We wanted to get out, but we are not going to get out under those conditions.
Right. And if you had signed that agreeing to a Munchausen by proxy diagnosis.
You're admitting guilt or blame. So
And what would happen to Beata's career as a nurse if, to the best of your knowledge, if she admitted in a document to being the person behind the child abuse of Munchausen by proxy?
Objection, lack of foundation, speculation.
Overruled, you can answer.
she wouldn't have been able to do her job with that allegation against her.
And later, did you learn that had that allegation become stuck in Maya's record, medical records, what the
Yes,
effect
it's-
would be on her?
It's still in there. And I mean, if something happens to Maya and there's nobody around to say what happened, she may not get the proper treatment because in her record, it shows conversion disorder or fictitious disorder. Somebody could take that right away and think, oh, this girl's faking and not get the proper treatment. And that is disgusting that we have to live that way with that in her record.
All right, so how was it in terms of the stress on you and your wife, knowing, as you've just testified, that you needed to get your daughter out for treatment and you were being kept in, that she was being kept in?
It was extremely stressful. Extremely.
And what was the fear there in terms of Maya's condition as she lay there
The
without
fear
you?
was that she's going to deteriorate, which she did.
And so now I'd like to talk about, from what you saw, the times when you had to let Maya know that you couldn't leave. She could not leave that place.
The worst time I could remember is when I was told I had to leave. That was on the 13th. I looked at Maya, and she looked at me, and that is burned into my head, that picture. Having to leave your daughter that was in need of their parent. I wish it was like an Etch-a-Sketch where I could tip it over and erase that picture, but it's burned in my head forever. And I think see that all the time. And I just wonder how she felt on the other side, seeing her dad walk away. And not knowing if she's ever going to see us again.
Did you feel as though you'd betrayed her in some way?
No, I didn't betray her.
Did you feel a concern about her medical, what could happen to her medically without you and Beata there to guide her and to assist her and protect her?
I was worried about that, and I seen it deteriorate when I visited her.
All right, so
Not only did I see her deteriorate, I seen my wife. I go to the hospital, I see my child deteriorating. I go home, I see my wife deteriorating.
and in one event, did Beata in fact lose consciousness, fall to the floor upon finding out she wasn't going to be able
We
to see
had
her
a
child?
dependency
All
hearing.
right, don't tell us about the context. Just tell us, did that happen in an event?
Pardon me? I'm sorry.
Yeah, don't worry about the context where you
Okay.
were. Just
Yeah,
tell
she
us.
fell and struck her head on the floor.
And so, through this period of time, as you were kept away from your daughter, can you tell the jury, did Beata's condition remain the same from what you saw as a husband, or did it continue to deteriorate?
I was asked by Dr. Duncan, why is Beata so upset? And why can she not calm down? And I thought about that, and I remember, I'll say this real quick, but my nephew and I were fishing, and he accidentally caught a baby alligator. And he was reeling in, and the mother came out of the water and chased us on a picnic table. And I told Dr. Duncan, I said, that's Beata. Her child is on the 7th floor, and she wants her child back. And she realized, at that time.
And so, as time went on, did Beata become accustomed to this, or did she continue to have these emotional, I guess, slide down?
It was all downhill.
And so, I guess from that story, did Beata have a strong protective instinct, maternal instinct?
The strength was weakening. She's just losing hope.
Yep. Now, after this point, you find out that the there had been a petition or whatever, and, but you were granted visitation, is that right?
I was.
And can you tell the jury whether this was just you being able to come and see your daughter, or whether you had to have someone with you?
It was arranged to be supervised visitation at first. I did take Kyle. I took Kyle with me the first time. That was on the 14th, I believe. And we drove from Venice to St. Pete to see Maya.
How often were you able to go?
Well, it was the drive there was an hour drive. And then when we got there, I called and I spoke with the nurse, and the nurse said that it has to go through the social worker. So she said she'd call me back. And then I was talking with the social worker, and I was disconnected. I'm not blaming somebody for hanging up or anything.
Did you ever, oh, sorry, continue.
But we were denied that day to see Maya. So instead of getting mad or anything like that, bit my lip and drove home.
Was there a feeling on your part at that time that if you started to raise a lot of noise about it, for lack of a better term, it might get worse?
Objection, and we need to, I apologize, but we do need to approach on this, Your Honor.
Okay. Approach.
Objection overruled.
All right, so I think we're gonna,
You're going to have to repeat it.
go ahead, tell the jury.
I'm sorry, you're going to have to repeat the question.
Oh. Well, that's gonna be interesting because I can't remember it. So I believe at this time then you were trying to see your daughter, and then
Yeah, the first time I was denied, so we drove home.
so what happened the next time, or what happened next?
I spoke with Kathy Beatty, and she stated that they will not supervise the visitations. It has to be by a third party.
Now, so was she saying that they were bowing out of this?
Objection calls for speculation.
Sustained.
Denied by whom? Who is Kathy Beatty?
Kathy Beatty's social worker at the hospital.
From your view, was Kathy Beatty more or less assigned to your daughter?
She followed Maya from the first floor and up to the PICU, yes.
Was Maya kept in just one room when you would visit, or were there multiple rooms?
It was multiple rooms, but, it would be a certain time frame in a room.
And when you came up to those rooms, did you notice whether or not they would put Maya's name on the door?
No, there would be no marking on the door. Most of the children had their name on the door, next to the door, I'm sorry.
Artwork?
And it's a little slate or something like that. Most of them had their names on, but Maya did not.
Ever
And
on any of them?
also, her name was not downstairs at the lobby if you're checking in. Her name was not there.
So if visitors came in to ask for Maya Kowalski, what happens?
She's not listed as a patient.
She became a non-entity? So tell us about after Ms. Beatty tells you they're not supervising anymore. How'd you manage to see or talk to your daughter?
We had to do a list of potential supervise or certain people, and never got anything back on that. But then it started out with a third party doing the supervised visitation on their schedule.
On their schedule?
Yes.
And were there times when you simply could not get in to see Maya?
Depending on the time, yeah, that's correct.
But throughout all of this, you were legally allowed to see Maya, were you
I
not?
was allowed.
Objection calls for a legal conclusion.
Sustained.
There was no prohibition, as far as you knew, on you seeing your daughter other than the practical.
Same objection, Your Honor.
That one he can answer.
I'm sorry.
There was no restriction on you seeing Maya other than the practical considerations of getting cooperation from the hospital.
Same objection, Your Honor.
Well, you changed the question, so I'm going to sustain that question.
All right. Let's just continue on. I'll come back to that.
Okay.
Tell the jury then about how you had to complete the list to get people in.
There was a list of family members, and then it was going to be, they'd do a background or whatever. I don't know what they were going to do with it, but I had to give them their name, address, social security number, everything. There was the only one that I know of for sure that's questioned was my brother Bobby. He questioned.
The same one that testified first?
Yes.
And was he a former police officer?
He was a former police officer.
Did they know
Bourbon
that?
Springs. Yes.
So what happened?
They said they didn't want family members to do the supervise visitations.
Okay. So now, the list then, was it a list for visitors or was it just for supervised visitors?
That one was for just supervise, and then there was no list for, or they didn't state that we had to have a list for visitors. No visitors were allowed at that time,
All right, but that's important now.
other than the teachers.
All right, I want you to explain to the jury a little bit more about this. So there's a list for the supervised visitors that were going to supervise where you were, but in terms of people that just wanted to come see Maya, like Father, the priest that came in, or Father Jack, or
No, the immediate family, we had the list, and that was intended as well as for the supervised visitation, but there was
Anyone
no list for just visitors.
and yet were other visitors turned away or told once they arrived in the room they had to go away?
Nobody could, if they went there to visit, she's not in the computer as a patient, so there would have been no way for them to go see her.
From what you saw, did Maya feel as though she was being isolated?
Oh, definitely.
So let me show you Exhibit 1081. I got it. Which is the 1081, and then we're going to go to 1082-0003, if we could. So that's 1082-0003. 0003. May we publish, Your Honor? It's in evidence.
It's in evidence, yes.
It took a long time, but one of her friends eventually did get the visit, one of her girlfriends.
And as we're pulling this up, her statement of rights, then, your statement of rights, you were allowed visitation, generally.
Yes,
And you were allowed to, for instance, practice cultural values and spiritual beliefs as long as they don't interfere with the well-being of others and are within the limits of hospital policy and the law. So was there anything that you, or to your knowledge, any of the visitors did that was disruptive?
Objection, lack of foundation, and misstates the evidence.
Overruled on that one.
anybody interfere with that visited? No.
Yeah, did the hospital, yeah, okay, that's what I'm getting at. From the best of your knowledge, did you or anyone else do anything that was against the hospital's rules?
No, we brought holy water. She had her wafers. She had her cross or the rosary, and a lot of that was not allowed to be in her room.
And so you brought it up, and was it then taken away?
It was taken away.
And did you ever learn the reason why it was taken away?
One thing that I remember is they were worried that the host was going to be poisoned.
That the body and blood was going to be
Yeah.
poisoned with what?
With what? Who
Yeah, what
knows?
was supposed to be in it? That was,
I have no clue what they were worried about.
well, did you ever learn through the course of this that they believed that somehow Beata was slipping ketamine to her daughter through the holy water and wafers?
Object, lack of foundation.
No.
Overruled.
They,
I know it didn't happen, but did you
it
learn?
didn't happen. No, it did not happen. But yes, they had all different ideas of
Theories?
theories, yes.
All right. And so, were you allowed by this rule to talk with another doctor or specialist to get a second opinion?
Objection, again, in terms of the time frame that this has been discussed.
Generally,
Well, I think Mr. Shapiro is correct. Are you talking about before or after the entry of the order?
this is after the entry of the order. Were they allowed to talk to another doctor?
I think you need to approach on that one.
objection to the last question.
Reporter, could you read that back, please, the last question? Make sure I get it straight.
Question, all right, so were you allowed by this rule to talk with another doctor or specialist to get a second opinion? Mr. Shapiro objection in terms of the time frame.
Just the questions only.
Discussed, and Mr. Anderson said generally.
There was a doctor that was under a court order to come evaluate Maya. That was Dr. Hannah.
What happened there?
Dr. Hannah was refused to see her by Johns Hopkins All Children's Hospital.
Now, in terms of the restrictions as you knew them, did you understand that you retained your rights to participate in and be involved in and advise and consent in the medical treatment of your daughter?
We had rights. We still had rights at that time, yes.
And so through all of this, did the hospital, any of them, actually involve you in any of their decisions on
No.
treatment?
No.
So were you under the patient rights thing? Here we have the 1082003. It states the third from the bottom of the first row to be told by your healthcare provider. Do you see that?
To be told of medical choices for
Yes.
care of treatment.
Okay. And so were you ever allowed that right?
No.
And were you ever allowed during the period of time that you were there with Maya to consult with any doctor outside of the hospital doctors?
I'm sorry, repeat that.
Were you allowed ever to suggest or bring in were you allowed to suggest other doctors outside of Johns Hopkins to come in and get opinions?
Predicate and foundation.
Sustained.
What, if any, knowledge did you have about the terms and conditions of why Maya was in there? Did you understand that it included anything that restricted you from participating in the health care of your...
No.
And through the course of this, did you have the opportunity, or did you request the opportunity to bring in outside non-Johns Hopkins physicians to look at Maya and provide second opinions?
Objection, foundation, predicate, and compound.
Sustained.
What, if any, doctors outside of Johns Hopkins got to see Maya? Was it
Well,
Dr. Chopra?
Dr. Hannah was refused, and then Dr. Duncan, she was able to evaluate when she went to the courthouse in Sarasota.
And then, and she testified here earlier?
Yes.
And then Dr. Chopra, was he allowed?
Dr. Chopra was after, that was in January. I went and seen, that was a court order as well. I had 48 hours to take Maya. I had to hire a nurse to go with, and I had to have a brother. And then I had a 48-hour time period. Otherwise, I'm in trouble if I'm not back in time.
And so tell us how you were treated on the times you could come in and visit by the staff, particularly Ms. Beatty.
Well, there's a time I walked in, the children were gonna be visit with their lawyer. We had 4 lawyers, I believe. The children had a lawyer, Beata had a lawyer, I had a lawyer, and we had something else.
Was that by choice or by necessity?
So I brought the kids in to see their lawyer at the hospital. I walked in, and a woman behind the desk, she asked me, what am I doing there? And I said, I'm Jack Kowalski. I told her who I was and that the kids are going to visit with their lawyer. And she started screaming at me that I don't belong there, and she's gonna call the police and whoever else because I don't belong there. And I said, I'm just here to drop the children off, or Kyle off. It's not like I'm gonna pull up and tell Kyle to go inside the building and go see his lawyer. I had no intention of going upstairs with him, but to just get him to his lawyer. But she screamed at me, and I just walked out. Once again, I'm not going to cause any interference because I do not want to lose my privileges to see my child. That's the only basically the only one that could go see her at that time. Eventually, I found out who it was. The woman's name was Judy. After other visits, I seen her name tag. But there was another time during this whole time. There was supervised visitation. Then it was unsupervised for a while. Then they said Maya's condition's getting worse, and it's Dad's fault for visiting or interfering with her PT and things like that. So the court order changed so much, and all this information was from one side, the hospital. We had no say so that we weren't interfering. So yeah, there was so many interruptions. And then one time I got a new court order, I bring it in, and Elaine Brown, she's a social worker. I called and told her I was here because then now I have to check in with the supervisor again from the hospital. She came down finally, and she said I couldn't visit yet because she's unaware of the order, which I had in hand, and I provided her with it, the new order. She said that I could not go up there until it's reviewed by Kathy Beatty. I did have dresses for Maya for the holiday, so I asked her if she could give them to Maya. Later on, I found out those dresses never made it to her. They were in Kathy Beatty's office.
Man, you saw them there.
Yeah. So,
But hang on. You were giving things to the hospital staff to pass along to your daughter? Is that right?
yes, anytime we brought anything in, it had to go through them. They had to look through the bags. They had to check everything. Envelopes to whatever.
What about bringing in a snack for your daughter, like a brownie or?
I had to get permission of different food items. They had to be in a closed container. You couldn't bring in carrots or something Mom made. That was not allowed.
So she had to eat hospital food?
Hospital food, and then some snacks that are in a closed container, in the original package.
From what you saw, was your daughter gaining weight or losing weight in the hospital?
She was losing weight. She was deteriorating, and at the end, she was puffy, like she had a lot of fluids.
And so, were there any other times then that you had either gifts or something for Maya that was interfered with that you can think of?
Yes, well, there was an issue with her computer, the school computer. She wasn't allowed to keep it in her room, according from Kathy Beatty. Kathy Beatty stated that she may be going online to see some sex
Objection
sites.
to hearsay,
Part of it, admission.
and also the motion.
Were these statements made to you?
She wrote the little note.
Well, to the extent that they need to be statements to him, so I think that question is sustained.
From your overall communication with Ms. Beatty, did it become clear to you that, let me see. All right. Let's move back then and get this right. I need to know more about the details of this dress incident. What was the purpose there? Was it just a gift of a dress?
No, there was a holiday coming up. I believe Christmas is when that happened.
And was the dress a Christmas dress?
It was a dress for the holiday, yes.
And were these things important to Maya?
It was important to Maya, it was important to Beata, to have her celebrate.
Did you ever come in and expect to see your daughter in the dress and learn that she never received a dress?
Well, that was the way I found out. I asked Maya if she, how she liked the dress, and she looked at me like, "What dress?" So
And then what did you do?
then I contacted Elaine Brown, and she goes, "Oh, it's in Kathy Beatty's office. Found it in Kathy Beatty's office."
Did you confirm that?
The dress ended up getting to her eventually.
But you had to go around Miss Beatty.
Yes.
Did it appear that Miss Beatty was operating under some kind of plan in terms of the way you and your family were being treated?
Objection, leading, and speculation.
Sustained.
What, if any, plan did it appear that Miss Beatty was adhering to?
Same objection.
The plan, motive,
I'm
intent.
going to overrule the leading, but the other basis I'm going to sustain.
Which basis, Your Honor?
Speculation.
Yeah, thank you. And foundation as well.
Foundation.
Okay. So, was Miss Beatty's actions towards you, did they appear to be consistent with some idea?
She was in control. I remember an incident that happened to me, and I'm not talking for Maya or anybody else.
Objection to non-responsiveness.
Overruled. He can complete the answer.
One day, she walked up to me and she asked me, "Did you ever consider divorcing your wife?" And it's like, "What are you talking about?" And she goes, "Oh, forget it," and walked away. And it's just like, why would you even come up and say something like that?
Now, the jury may hear testimony from your daughter about Miss Beatty's physical contact with her. During these conversations, was Maya ever allowed to tell you about those?
By a note.
And so, what was the effect on you and your wife about knowing what Miss Beatty was doing?
It was just putting a bigger wedge in between everyone, and more anger.
Well, was Beata becoming more desperate at this point?
Yes.
And what was her concern?
Number one, Maya's health.
And were you reporting back to your wife about her health every time you visited?
Yes, and yeah, it was difficult.
Well, when you came home then, was she nonchalant about what Beata was like, or was she desperate for information for what she was like?
She would want to know. Then she would want to know how she's being treated, but I wasn't getting the answers. There's many times I seen Maya in a position or in a situation where her lesions are hurting, the dystonia, and I brought that up, and there was no answers. There was one time they said they bring an ice pack for her lesions. The ice packs, or lesions and pain, the ice packs are not going to help.
And we're going to refer to some covert video on this point in a moment, but going back to the dress, who picked out the dress for Maya?
Mom.
So what was the effect when she heard that Maya couldn't even get the dress?
I crushed her.
Did it appear to you that Miss Beatty was potentially a danger or a possible means of inflicting harm on your daughter?
Objection, speculation, predicate.
Overruled. He can answer that.
I was worried from what I seen in the notes
What was your worry?
Well, I don't know if I could bring a certain thing up, so.
Okay, well, let's approach sidebar and see if we can. So now, was the incident involving Kyle, was that the October 27th incident for bringing Kyle in yourself?
No.
Was there another incident where voices were raised about you bringing your 7-year-old son in? For bringing the children to their lawyers?
I just remember the one where
All right,
having them meet with their lawyer, Mike Kelly.
all right. And so now, did there come a time when you were going to take Maya to the Fall Festival?
Yes.
What happened there? And what was the Fall Festival first? So you have
Fall
some idea?
Festival, they have an outside playground on the hospital rooftop. And they also have a rec center. The rec personnel, young girls came in and they introduced themselves, and they stated that they have a fall festival going on and they want Maya to attend. So they got the kids all excited about the fall festival, and then we were gonna go to that location, and then we were told we're not allowed to leave the room. And they stated that your visitation is bedside only. And I said, well, first of all, I asked the nurse, we are not to discuss this in front of the kids. So I went out in the hallway for respect, so they don't hear what's going on. And I had the order, I showed it to her, and she said no. Right here it took a while, I had to go through different people, but finally I was able to see it on their screen. She showed me, and it was an order from Kathy Beatty that I am not allowed to take her anywhere but be in bedside with her visitation. So I contacted my attorney at the time, Deborah Salisbury, and it took some time, and then eventually we were able to go to the Fall Festival.
And were you ever, did there come a time you learned that some covert video surveillance was being performed on your daughter?
I had no clue that was going on until many
This
years
case?
after.
And what specifically did you understand Maya was forced to do?
Objection, foundation, and predicate based on last response.
Well, I'm going to sustain that, but you can ask some foundation questions on this issue.
How did you learn about the covert video surveillance?
During the legal issues.
And were you questioned about it throughout this proceeding?
Yes.
And prior to that time, were you allowed, prior to that time, by terms of the orders and the patient statement of rights, were you supposed to be informed of any medical procedures that your daughter was to be involved in?
Objection, compound, and foundation.
Overruled. You can answer that.
Yes.
So during this period of time, were you kept up to date about what was going on with the different attempts to, quote, treat your daughter?
No.
And so, did you subsequently learn then that there was video surveillance undertaken of Maya?
When I found out about that, I was very upset. We did not give consent to that.
Did you learn that from October 18th to October 20th, she had been put in a surveillance room?
That's what I was at quite a while after I learned of that.
I understand. Now, Maya had been videotaped at Tampa General Hospital briefly, had she not?
Yes.
Did you give consent at that time?
Yes, there was an incident where Maya fell out of the bed at Tampa General, and they notified us, and then they also wanted to do video surveillance, you know, to make sure that it wouldn't happen again, or they could monitor her, and we gave consent to that.
Well, it would also have told them that if she got up out of the presence of anybody and walked around rather than standing in her wheelchair, right?
Objection to leading her.
Sustained.
What, if any, other benefit would it have been?
To see her condition and, you know,
To see if she
that
could,
she's safe as well.
yeah. And also, was it also, to the best of your knowledge, to see if when she was out of sight of anyone, she would actually get up and do more than she seemed to be able to do at that time?
I'm not aware of that.
Okay. So now tell us then, before October 18th, were you ever informed by the hospital that they intended to put your daughter in a room alone?
Absolutely not.
Were you informed that they planned to test her as to whether she could actually get up and walk around by placing the commode just out of reach?
Objection, predicate and foundation.
Overruled.
It was the commode and also the phone. They would ring the phone, see if she would answer the phone.
Were
Which
both
was
of
out
those,
reach.
and both of those were out of reach?
Yes.
Had you been asked about this, would you have given consent or told no?
Absolutely not.
And so I'd like to publish for the jury portions of 2703. That's 2703 A, B, C, and D.
They're in evidence.
And those are in evidence, I believe, right?
Yes.
Yes, Your Honor.
You may.
Now, in this video, go ahead. You can continue. Okay, let's freeze that for a moment. So during the time that you took care of your daughter, periods, was part of that treating the lesions?
Yes.
And did that include putting certain types of medicated lotion or salve on them?
Yeah, there was an ointment. It was a ketamine ointment that was used, prescribed by, I believe, Dr. Hanna, and that was through King's Pharmacy.
And so here, can you tell the jury what Maya's doing with that jar?
For what I heard, she was explaining to the nurse what they are, and it from the RSD, she stated, I believe, in there. So she's telling her that's what it is. Later on, the hospital was stating that she was self-inflicting herself with wounds.
And here, based on your knowledge, your daughter is actually applying a salve to the lesions?
Correct.
And do you see where the lesions were?
On her legs.
And is that typically where you saw the lesions?
She has lesions again on her legs.
To this right now,
Right
it
now.
does. Okay. And how is she doing right now? Just out of
She's not. She's weak.
she still has good days and bad days.
Yeah, there's bad days right now.
All right. Now I want to show you another one, 2703. Oh, wait. While we're on this, you see the location of the commode?
Yes, I do.
Was Maya physically able to make it over there to go to the bathroom?
No, if you've seen the nurse, she assisted lifting her legs and that. She's weak.
All right. Did it come to your attention that there were times when they wouldn't come fast enough for Maya to make it over to the commode?
She wet herself several times. And I don't know if you could see on the right side there, her feet, the dystonia, they're severely turned in. The right one.
Right there?
Yeah.
Okay. Now, let's talk a little bit about the blankets over her. With the aldinia, what, if anything, is significant about the blankets versus people trying to reach out and grab her?
Well, the blankets can affect it. Just like I said, droplets of water in the shower. But a person, sometimes when it's severe, even with the person going near her, she'll retract. I don't know if you're going to show it, but there was a video of Kyle. He actually touched her legs and they spasmed. But it's all dependent on the day as well.
All right. And so,
as you see, she's in shorts. It's probably the most comfortable thing for her to have on instead of long pants where it would potentially irritate.
and I note at the end there, she kept the blanket off.
Yes.
All right, let's look at 2703B. If we can. Does that keep going?
That includes it.
That's it. That's it.
Okay. All right, and so that position of the commode, again, could Maya reach that?
No, did you see her legs? She's so weak. They're so weak, there's no way that she would have been able to.
And let the record reflect that this was performed, this happened October 18th through October 20th. Now, does it appear to you, or did it appear to you, that this room was darkened?
Yes.
Do you know why or what they told your daughter in terms of the reasons she needed to go into that room, as opposed to telling her that she was going to be videotaped?
They told Maya that they changed rooms after a certain time frame.
Do you recall them expressing that they were doing an EEG on her?
No.
Do you recall Maya talking about the fact that they told her that what the room was for was to put EEG, try a new type of EEG on her?
No.
So why was she in this room?
Why wasn't she in there if they were worried about her self-inflicting her, wounds? That would make more sense to have somebody under surveillance. But when that took place, she was not under surveillance when they accused her of scratching her face and that.
I see. So did they ever put her under surveillance when they started to accuse her of self-inflicted lesions?
No.
Now, from your perspective, having been through there many times, did this hospital have surveillance cameras throughout?
They're everywhere.
Hallways?
Everywhere.
Outside of the chapel area?
Yes.
Lobby?
Yes.
As you walk down the hallways, surveillance?
There's no way to go anywhere without a camera.
And in this case, have you actually seen a clip, an excerpt still from one of the surveillance cameras at this time?
Objection, I apologize, I do need to approach on this.
members of the jury, given the time, it probably is the best time to just take a break. So, do not discuss this case amongst yourselves, do not do any investigation, and receive no information. This is probably going to be a 15-minute break, so we'll see you on the flip side.
All right, for the next take.
Okay, please be seated. Mr. Kowalski, you're free to go on break. If you want to go sit at your council table, that's fine. If you want to sit there, that's fine.
Thank you, sir.
Now, Mr. Anderson, I don't recall if we're talking about the issue of spoliation. Obviously, it's not play, but there's certainly other ways to deal with spoliation. But there's almost always, I'm presented with a, look at this discovery request. They didn't produce. Let's do something about it. I don't recall there being a discovery hearing relative to this outside video surveillance. But if I'm wrong, just can you point me to the hearing or the order that I entered, if any?
There's two issues. One is the surveillance in the hallways, and the other is the surveillance the court is witnessing in this 2703. We made a request for production for any and all video, among other things, depictions of Maya Kowalski. That was not produced. They said, no, nothing. There was nothing for us to really bring to the court's attention. Further, later on in the litigation, actually fairly recently when we were going, to my knowledge, when we were going through the potential exhibits for here, and maybe a little before, but frankly I can't remember exactly when, but it was fairly recently, we saw this photo which was represented to us to be a still out of the surveillance cameras that they intended to use for some reason in their defense.
Can I see that so I have a context of what we're talking about?
Yes. Do we?
It's gonna take 1 minute.
That'll take a minute.
You can keep arguing, but let's.
Sure. So DCF made a request for this specific video. And it was,
With this specific video, meaning the EEG room?
yes.
No.
Go ahead.
First week of her admission,
Sorry.
DC
That's
sent a
another one.
request for surveillance video of Maya Kowalski, which would include the hallway video, the video of her rooms, the video of her in the PICU. It was never produced.
To DCF.
Correct.
So there was a DCF request to Johns Hopkins in the lawsuit or during Maya's stay at Johns Hopkins?
Not in this litigation, in the underlying litigation. Dependency proceeding.
In the shelter action, DCF requested, and I got confused because there are two. DCF requested the surveillance because the entire hospital is surveyed. And so in that proceeding, they made a representation on the record that they had no such surveillance. And I believe in deposition, I also asked, do you have this surveillance? And the answer was, this is only kept for, and I'll have to dig it out, find the deposition. This is only kept so long we don't have this anymore. And so then from that followed up an entire series of questions about, well, why wasn't it preserved? But we had nothing really at that point to argue with. They had it, they should have kept it, they didn't, it's not there, it's not something that they can keep producing or that we should keep asking about. Subsequently, we got this photograph, which is a still out of one of those cameras, or so it was represented to us. That's when we came to the conclusion, well, they must have kept some of it, so where's the rest of it? And we didn't bring the matter up to the court at that point because frankly, I think discovery was either closing or close to close. And for their representations in the court, they said there's none. So our point of view is we should be able to lay the foundations here for the fact that there was a photograph extracted from that.
In this lawsuit, 2018 CA 5321, did the plaintiffs make a discovery request for any type of video surveillance out in the hallways or outside or anything having to do outside of the EEG room?
I believe so. I think perhaps the solution is to not pursue this at the moment and allow us to provide the court with the request and the DCF request and the still frame.
And hopefully my series of questions about it.
I don't think I could address a discovery request made in the dependency court that wasn't properly addressed or responded to in the dependency court. I could only deal with a request that was made in this case, 18 CA 5321. So I am still trying to figure out what we're talking about. Can you at least show me this still,
Sure.
what we're talking about?
Do we have that?
Still,
And if defense counsel has it.
Hero, do you know what?
Judge, let me just say this.
3127.
I've asked of our folks, I don't remember any request to us regarding hallway or general area surveillance. We're checking to see what the situation is with respect to that. I can tell the court that during the dependency action, there was an informal request made by Deborah Salisbury for the surveillance video that is being shown here that plaintiff produced to us in pre-suit because they had it. It was provided to Ms. Salisbury. We have the FedEx receipt to show that. And the question may become, gee, if she knew to ask, how come you didn't know what was happening? Obviously, she knew to ask. But whatever the case, this surveillance that we're seeing clips of here was provided informally upon request. Now, as far as these hallway surveillance is concerned, those are running tapes that get taped over, to my knowledge. I don't know what the time frame is off the top of my head, but I'm not aware of any request for any of those things in this action, or for that matter, in the dependency action. This is nothing but gotcha.
Well, I would like to see the still photo, but the reality is there has to be a discovery request in this case that then there was some sort of follow-up on.
I can address at least the discovery request, Your Honor. It's our fourth request for production. Number 3, we asked.
Can you give me a den?
No.
What's the date of it?
I will. One moment.
What's the date?
All I have in front of me, Your Honor, is a text message from Miss Perry, who's still sick. It's our fourth request for production, request number 3. Please produce all video recordings of Maya Kowalski and her family during the relevant time period. I will get a den and a date of that request in response.
Just very briefly, Your Honor, because I know the court wants to take a break. It's not a request for hallway surveillance, but getting to the point that this court's making. For them to pursue spoliation, they have to have a request. There has to be a showing that there is a duty, that the information no longer is available. There has to be a duty to preserve, that the court finds that the failure to preserve it violate a legal duty. They haven't even met the second step, let alone third, fourth, and fifth.
It's because we haven't had an opportunity to make our foundation and predicate for it. And I don't agree.
So
that
we started this line of questioning spontaneously off the top of our heads?
No, this has been asked repeatedly. And this, I believe, was asked.
Well, time out. I'm gonna go take a break. The reality is there's gotta be a request in this particular case. And before we can do anything else.
Yes, sir.
And unless and until that has happened, then none of this is something we need to be spending any time on.
I understand you.
Okay, why don't we just take 10 minutes?
All rise. Let's go ahead and
there anything further on the alleged spoliation issue, or are we moving on?
I believe we have found what the court was looking for. There are two things we'd like to do. First, put up Exhibit 3132, dated October. It's a, well, you'll see, clip dated October 25th, 2016, which the record reflects is while Maya was in the hospital. And I believe that the witness can identify the two people in that video, in that takeout. And then we have also the request for production. We have that.
What's the exhibit number?
Republishing 3132.
3132,
Defense exhibit.
defense.
Okay, so what is this?
This is a still frame from Johns Hopkins surveillance video, and this is Linda Brown and Joyce Sacco. You might remember the witness with the hat. She's wearing a hat here as well. And they're carrying in the statue of Mary.
Not sure that's our video.
And I see handwritten something about October 25th, 2016.
Yes, Your Honor. That's described on defense exhibit list as photo of Linda Brown and Joyce Sacco from security camera at JHatch 102516.
We have the
Now,
request.
what's your discovery request?
The first we'd like to show you is at DIN 56. It's our interrogatories. I can show you, and this is the responses which were not filed, but the requests were filed. And number 7 here, we asked for anyone at the hospital who had knowledge or possession of any videotape pertaining to the issues in this case, and we were told there were none other than medical records and related imaging studies.
Was there a request for like security cameras or anything that would be more specific than this very generic
We
request?
also have DIN 433, which is the request for production mentioned earlier. We can put that up.
What
And
request number?
Number 3 here. Please produce all video recordings of Maya Kowalski and her family during the relevant time period.
That's DIN 433, Your Honor.
Right, that looks like the hospital's response, which would include the request.
Yes, sir.
Was there a request for security camera?
In the interrogatory, we asked for anyone with knowledge of any video recording. We were told there were no such thing. We did not discover that to be untrue until we were given Exhibit 3132, which we just put up for Your Honor.
And there would be no reason to bring up to the court any type of search the way we did for the cell phones, because they say they simply don't have those. It's not like there were cell phones and we had to get information off. We had nothing to get information off of.
Judge, I'd like to get that exhibit back up, because if the court noticed, that has a plaintiff bait stamp on it. I don't know where that came from. I am skeptical that it's off our surveillance camera, notwithstanding what was put in the exhibits or not. But what I do know is this: when this thing came in to begin with, there was no request for any surveillance information from the hallways or security cameras. We answered it with reference to videos and images of the Kowalski family, just like it said. And we told them that the only ones that we were aware of, besides imaging studies, were the ones that we had produced to Ms. Salisbury, that they produced to us, because they're the ones that had them, and we had recorded over in the ordinary course of business those surveillance tapes. So if you notice this one in the bottom right-hand corner, it's got a plaintiff bait stamp on it. Now, I don't know where this came from off the top of my head. I do know I'm dodging gotcha all over the place, but I don't know either where it came from or who put the lettering at the bottom.
Well, let me just say this. The two requests that you showed me are not specific enough to specifically ask for security footage that might exist relative to what's in the hallways or outside or any place.
Your Honor, if we ask a question as to whether it exists and we're told none, how are we supposed to make a follow-up request? We take them at their word at that point, and we're shown later that's false.
Well, your client just testified that there's security cameras all over the place. So obviously, your client knew that there existed security cameras. So it would seem to me like if you wanted security cameras, that you would ask for security camera footage. I mean, that's what I see in slip and fall cases.
But if they tell us none exists,
Well,
why would we
I don't see that in either of those two responses.
in the interrogatory response, we ask for anyone that has any control of any video, and they say there is none other than the medical record and the imaging studies.
Did you? And I would say that you need to ask for security. You need to kind of actually give them an idea as to what you're asking for, not just an extremely open-ended, every single possible video in the world. You needed to say, hey, security cameras, give us the security cameras.
I would point out, Judge, that they never raised an objection to this as being overbroad or vague. They simply answered it in a way that makes clear that there are none of any of those kind. And so they had every opportunity, if they felt as though we were being vague about it, to raise that and to come in now and for them to say, oh, but it's not quite enough. It says, please produce all video recordings of Maya Kowalski. That would include video surveillance, and that was the intention behind it, and everybody knew this. And so we were trying to obtain this type of information, but you don't know, especially back then before we had done our inspection at the hospital, we didn't know the extent to which every freaking place in there has a video camera. They say they didn't have it, and they had every right to tell us that we don't understand what you're looking for. They didn't do that. They said they just don't have any in their possession, custody, and control. And right now, the only question before the court, I think, is can we have the witness identify that photo as Ms. Sacco and Ms. Brown?
Judge,
Mr. Hunter, unless the plaintiffs can show me a more specific request, that's not what you've shown me is not enough for me to walk down a spoliation path on security footage.
We'd like to show you one more thing, Your Honor.
Well, then show it to me.
2277-143.
Is that a defense? Oh, that's 2217.
No, it's 2277-143. This is from the hospital's risk management file.
Okay, that's talking about in the room. It says it twice. Doesn't talk about the hallway cameras. And that's not a discovery request.
Well,
So,
it's not in this proceeding, but I think the point.
I'm done with the spoliation issue. Those two items were not enough to drill down on a spoliation issue with respect to security footage, even if that is from the defendants. So let's move on.
I'm not trying to.
Mr. Anderson, I'm done with that issue. Let's go to the next issue.
I don't know of any other issue.
Okay, then we can bring in the jury.
Yes, Your Honor.
We will have to take up the matter of the liens in terms of a stipulation.
Everyone, please be seated. At least I didn't say 5 minutes this time. Members of the jury, I want to confirm that while you were away, you did not discuss this case amongst yourselves, you did not do any investigation, and you received no information. Is that all correct? Correct. And while you were away there for a few minutes, no one approached you about this case. Is that correct? Correct. And you did not observe any sort of media reports about this case. Is that correct? Correct. Okay, Mr. Anderson, you may continue. Oh, Mr. Kowalski, if you could come back down. And you understand, sir, you're still under oath?
Yes, sir.
Thank you. Mr. Anderson, you may continue.
Did there come a time that you began taking photographs of Maya and her different symptoms on your own?
Yes, within the hospital, yes.
All right. And why did you do that?
There was many times that we reported something and they denied or did not take care of, a lesion or her dystonia, things like that. So I started taking pictures. And then after reading some of the medical records don't even indicate that she has a lesion or so. And we have a picture on the same date where she has lesions.
Can we put up these photos, some of the photos, run through them?
You have an exhibit number there?
It doesn't have, I'm hoping you guys have the Kowalski photos.
Do you have an exhibit number?
That's what we're looking for right now. It's not on my outline. While we're finding those, what we're going to do is play the remaining two of these videos, if we could. One is 2703C. We can do that. Now, Maya pulling her knees up to her chest like that, what did that usually indicate to you?
Well, did you see her, she pulled her knees up, but did you see her use her hands to pull her legs up?
Yes.
And then also, I don't know if you noticed, she has a thing on her forehead. That's for the sensitivity of light. She has a little eye mask or something to cover her eyes if the light's bothering her. But when she got into the bed, I don't know if you've seen it or not, but she actually physically used her hand to lift up her legs.
Now, from your knowledge of CRPS, is light sensitivity one of the symptoms? Or
That is one.
Objection, predicate.
Overruled.
Sorry.
No, you can finish your answer, sir.
Yes, it is.
All right, let's play 2703D.
They're only supposed to be like $1, right? Or like really cheap.
$1.
Yeah.
Like normally $1.50, but the more shopping for that is cheaper.
Oh, really?
Then she has your medicine, which should be helping a little bit. I want to try to use the walker just to stand, pivot, get in the chair, like you did with Becky the other day. So I'm jealous that she got to see it and I did not. So I'm going to help you, but I want you to try to get your feet flat on the ground. I'll hold you up, get your feet flat. Put your feet down.
You got it. Good job.
Turn the walker.
You got it.
Better than yesterday. Hey, give me a high five. That was awesome. Better than yesterday.
You got it.
I wish we had the feet for you. That was awesome. Great job.
It's gonna hurt just a little bit because you haven't put any weight on the leg in a long time.
Were you able to hear her moaning and crying?
Yes.
Is that similar to what you heard previously when your daughter was in significant pain?
Yes, and sometimes it could be worse, but as you could see, she was trying to use her arms as much as possible. That's not a child faking.
And does this demonstrate, based on your knowledge of your daughter and the times you were seeing her at this time, the type of shape she was in?
She was getting worse.
As she entered the hospital, was she almost to the point of getting up on a walker and maybe with just a tiny bit of assistance getting around before the relapse?
Yeah, before the relapse, she was outstanding. Upper body strength was extremely well. And like I stated earlier, there was a picture where she's actually using her arms to support her whole body off the ground. She looked like a little gymnast. But no, now we just see her going downhill again.
Did Maya report to you during this period of time that this physical therapy, as opposed to warm water therapy, was actually hurting her?
There was no warm water therapy here at the hospital.
So was this therapy painful for her?
Yes.
And she
And
expressed
it's
that?
usually not, that don't appear to be the proper therapy for CRPS.
What's wrong with it?
It's too quick. You got to do things at a certain pace. I don't know if Rachel explained that from agility. You have to, first of all, build up certain things. And I believe the young lady from Tampa General, she also stated that. You gotta do it in steps.
Okay, so let's then jump to the photographs that you took that we alluded to just a moment ago. And I believe after October 20th, Nick has reminded me, after October 20th, when you witnessed or when you visited, did anyone tell you at the hospital about the video, that is, the one that had just completed, about Maya's difficulties in the surveillance room?
Not at the hospital, no.
And had you had that complete video, would you have used it to demonstrate that your daughter actually was doing a lot worse than being represented?
This would have helped paint the picture to the judge.
Sustained.
I'm sorry.
Was that video of value to you in defending your family?
Objection calls for speculation there.
Sustained.
What, if any, use would you have made of the information had they told you about this video?
Same objection there.
It's not speculation.
Okay, you can answer that question.
We would have took this video to prove Maya's condition. They were, unfortunately, it was a one-sided story. And we had no, if we had this would have painted a better picture to the judge at that time. And we probably wouldn't be here today.
So let's go through the lesion photos if we can. 2571-001. And after each one, I'll ask you to just kind of tell the jury what they're already seeing.
Your Honor, I apologize.
Approach.
Yeah.
Jury, I'm going to ask you to step out for a few minutes. Do not discuss this case amongst yourselves. Do not do any investigation and receive no information. Presence. Now, Mr. Anderson, I know we've discussed this before we even got to trial. The information was the plaintiff's attorney had this video. Was it November 6th or November 7th?
No, later. The date's important.
Okay, well, tell me the order I entered on this. Give me the DIN number on that, because I distinctly recall it was like in early November.
It's mid-November, Your Honor, you're correct.
Mid-November.
Yes.
Okay.
And just prior to that, there was a dependency review hearing on November 8th and November 10th. And Mr. Kowalski did not have this video or the benefit of it during the dependency review hearing. That's his testimony, that would have benefited.
It's not exactly what he said.
No, it
And
isn't
it's
what
also contrary to both the order and the implication, because the specific order from the court was the plaintiff can't contend.
Can someone give me a DIN number,
Sorry,
please?
yes, Your Honor, the DIN number is 3032.
3032.
For which now? For the actual hospital video?
This is the order limiting false imprisonment until after that date of November 16th or something.
I guess November 17th, not November 7th. I agree with the defense on this, Mr. Anderson. As of November 17th, there can be no concealment issue with respect to this video because the plaintiff's or Mr. Kowalski's attorney had it.
Judge, at that time, we did not have all of the information from Deborah Salisbury, and
Are
here's...
we all working on a curative instruction at this point?
Yeah.
Because one's coming.
I would ask that you, and we can bring Deborah Salisbury in, this is all planned. And I did not understand the limitations on this video being provided to Deborah Salisbury. Here is her testimony. We can bring her over here right now to do it. Her testimony
You
is...
didn't understand. The court grants the motion to the extent plaintiffs seek to contend there was any fraudulent concealment on or after November 17, 2016 relating to the secret video surveillance. What did you not understand about that?
I would like relief from it.
Okay, well, that's not what you just told me. You told me you didn't understand it.
Well,
So
maybe I got the... I got
you're
the...
asking
Wait.
reconsideration, or are you telling me you didn't understand the court order?
What I did, I may
Can you
not have
answer
gotten
my
straight.
question? Please answer my question.
I think I got confused on the court order as to the dates. That's the only thing and frankly, that was not the purpose of my question. I just asked whether it would be useful for him.
So the next decretal paragraph, the court denies the motion to the extent plaintiffs seek to contend there was fraudulent concealment prior to November 17th.
Judge, that's for the count on fraudulent concealment, is it not?
So are you saying this is medical malpractice?
Yes, and I'm also saying that it's part of our intentional infliction of emotional distress.
Well, to the extent that you are saying that there's an issue in the dependency court, you got a Chapter 39 immunity problem. So you
understand
can't
about
do that.
But I think what I can do is show the basis of what was happening there in terms of whether Ms. Salisbury actually had enough of the video. And what the evidence will show is that it was brought over to, or she was brought over to defense counsel's office not at DCF, but at Hill Ward and Henderson, and was shown snippets of it on the basis and telling her that this video, all this video shows is that she's in bed and we're going to use it to show that she's moving around. Miss Salisbury asked for it. She didn't get it. She finally got it. Then by the time when she got it, she couldn't open it. We've had that problem before because she didn't have the codes to open it. So during the pertinent period of time, she did not actually have the video. What she had seen were about 3 different 2 to 3 minute spots. And what they were telling her was, we're going to use this to prove that Maya Kowalski can move around easily. And so the problem is she did not have, and we did not have until this litigation, the complete video to be able to look at it and pull out the things that the court just saw. And so we intend, if the court will allow it, we intend to show through Ms. Salisbury that contrary to their representations, and insofar as this being part of the Chapter 39, the Hill Ward and Henderson was not supposed to be a prosecutor or a defense attorney in this. They were simply supposed to be a participant. So why they had this taped and we're going to show it and make representations about this is another issue. But to the extent the court believed that Ms. Salisbury had the complete use of it, and therefore that is impugned on the plaintiff and then impugned onto our representations, that is a false statement. What Deborah Salisbury had were isolated clips under a representation. As a good counsel, she asked for it to receive it. When she first received it, it wasn't from DCF. It was from Hill Ward and Henderson. And so at that point, she attempted to open this thing. This is going to be her testimony. I'll bring her over right now if we need to. She attempted to open it, could not open it, had to obtain a code, a special means of showing this. Apparently it's coded some way that's difficult. And I'm not sure the timing after that, but I do know it was late in the proceedings, very late in the proceedings.
Well, one, you told me the issue that Ms. Salisbury had about 6 months ago, and I think you also talked to me about it 2 years ago. And you did not bring any testimony from Ms. Salisbury at any time. I don't recall after I entered this order on May 8th, 2023 at DIN 3032 that you filed any motion for relief from that. The time for discovery is over. Trial is not supposed to be by ambush in the state of Florida. Everyone's supposed to know, both sides are supposed to know what each side has. And I am sorry that you seem to misunderstand the court's order talking about this issue.
Only as the timing, really.
Yeah. Before and after November 17th, I don't know how more clear I can be, but be that as it may, I'll grant you that you might be confused as to the meaning of November 17th. I need you to try the case and not continue to be on discovery. We were ahead. The last couple of days have been very bumpy and we're starting to slip. We've got a jury that continues to go out to deal with issues that should have been addressed before we even selected a jury. But we're at where we're at. Discovery's over. Trial. We're going to live with the orders that were previously entered. If you don't understand an order, please let me know. Hopefully timely.
In our defense, I believe that was an order in limine.
It was an order granting and denying.
Regarding summary judgment on count 20.
I believe there was a follow-up motion in limine, and what I understood from the court was that since we had, I don't know how many motions in limine in this case, going into the dozens, that if there was an issue which arose at trial, that the court would reconsider.
Outside the presence of the jury.
I didn't know he was going to say that, Judge. I just asked him if it was of value to him.
Yeah. Well, and
And the next-
reality is, well, let's just go with What do you have,
I'll
a
be
recommendation for the proposed
Can
curative?
I'll make the record and then Mr. Alderman will make it, but here's the reason why this is extremely problematic. The video, as Your Honor noted in his orders, was turned over to Ms. Salisbury on November 17th, 2016. After the Kowalskis received the video, there was a shelter hearing on December 5th, 2016, and there was a shelter hearing on December 13th, 2016, both of which at a minimum would have been opportunities for the Kowalskis to present whatever evidence was in that video to the DCF court. So there's been a false implication in front of the jury that video, if provided timely, would have changed everything and Maya would have been home. It's also relitigating the DCF action, which this court has instructed both parties on numerous occasions not to do. My colleague, Mr. Aldenburn's working on an instruction, but we're very, very concerned about the last statement from Mr. Kowalski on the witness stand, that if we only turned over the video, everything would have been different. It's a clear violation of this court's order. It's a complete misstatement of the facts that the video was in the possessions of the Kowalskis for 2 subsequent hearings. And I think we have to move for a mistrial at this point, Your Honor. We would reserve on that until the close of the case, but we do have to mark for the record that we are moving for mistrial on that case.
Well, are you moving for a mistrial or are you not moving for a mistrial?
Yes, we are moving for mistrial. We'd ask the court to reserve on that.
Joe?
What, Mr. Altenburn, is your proposed language?
Your Honor, on the fly, I think from what I'm hearing that you should tell them that the jury is to ignore the testimony of Mr. Kowalski, that the videotape that was produced on November 17th would have made a difference in the DCF proceeding, that the hospital is not responsible for the orders entered by the court in the DCF proceeding.
Is that written out or is that?
No, I'm taking from my very bad handwriting to do that.
If you say it again, I'll write it.
Yes.
Can you read that to me again?
Well, the
Well,
court
I'm
reporter
just
took it
recite it
down.
again.
The court reporter took it down.
Can you read it
You want
back?
me to read it?
Yes, that's probably better. You can go from there.
Your Honor, on the fly, I think what I'm hearing that you should tell the jury is to ignore the testimony of Mr. Kowalski that the videotape that was produced on November 17th would have made a difference in the DCF proceeding, that the hospital is not responsible for the orders entered by the court in the DCF proceeding.
One point, Your Honor.
Your thoughts, Mr. Anderson?
First, for the record, the December 5th and December 13th hearings were not on any merits of the case. They were purely procedural to deal with how Maya Kowalski was being treated and how the orders were to be modified in regard to that. So there was no opportunity at those. Our concern in this, besides the fact from the defense's perspective, it just merely highlights the testimony. Our concern is this: until the court hears Ms. Salisbury's testimony completely, which I have summarized but by no means have made complete, we believe that it's objectionable to read any instruction that would diminish the plaintiff in front of the jury. And really, the question did not call for it. I'm sorry it went farther than I anticipated, but it was not intentional in any way, shape, or form. And until the court has all of the facts in this to make a determination, we do not believe that an instruction is important. We have to put on our whole case and at least get to Ms. Salisbury's testimony. And then the court can decide what it needs to do. For the record, I'd point out the number of orders in limine in this case makes trying to examine a witness a veritable minefield. And I simply wonder, given human beings being human beings, how it's, that it's going to be very, let me say this, it's very difficult for me up here questioning to constantly have to weave around these orders. It just, that's the problem with trying the case in limine. So I understand the orders are there. I understood that the court was open to them. As to the summary judgment, the only thing I got mixed up on was about the November 17th versus the dates that mattered.
Here are my thoughts. In response to Mr. Anderson's point, we'll just wait until we hear from Deborah Salisbury. The problem with that is, even assuming that Ms. Salisbury could not open the video, she had knowledge of the video indisputably no later than November 17th, and could have sought relief in front of the dependency court if she was having trouble opening it up, and could have addressed the issue in front of the dependency court. So here's what, based on what Mr. Altenburn said, let me read kind of where I'm at, but this is not a ruling. This is, let's just listen to it. The videotape that the jury has been seeing and discussing, or sorry, the videotape that the jury has been seeing most recently this morning was provided to the Kowalski family attorney on November 17th, 2016. The jury is instructed to disregard Mr. Kowalski's statement that the video would have made a difference in the dependency action. To be clear, defendant Johns Hopkins All Children's Hospital cannot be held responsible for court orders entered in the dependency action.
I think that's fine.
Your Honor, the second sentence there, that it would not have made a difference, implies that it could not have made a difference in the time before November 17th.
And that's our problem.
And that's our fraudulent concealment count is based on.
So would not have made it after November 17th?
Yes,
And it
that's
depends on
fine
how
after
much
some-
evidence we want to get in on this, because I mean, there were two lengthy hearings on November 5th and December 5th and December 13th.
Procedurally.
And no one raised this then saying, we want to use this to change orders or to do anything. And so then the argument's going to have to be that they would have done something in that 30-day period that they didn't do in the 30-day period after they had this, and when the hearings were also taking place. So this becomes sort of an inference on an inference kind of problem as to what a judge would have ruled if he'd known something on November 10th when they didn't give it to him on December 10th once they had the
I think
document.
we're now re-arguing the summary judgment. The court made its
Well,
decision
we're
November
re-arguing the
17th is the cutoff deadline. So we're allowed to pursue this up until November 17th. There were two shelter review hearings on the 8th and the 10th, lengthy, full-day hearings, where Mr. Kowalski had no knowledge of this video.
And they had a duty under their statement.
Time out. I think Mr. Whitney has a point. So the second sentence, let me read it and get everyone's thoughts. The jury is instructed to disregard Mr. Kowalski's statement that the video would have made a difference to the extent that such statement applies on or after November 17th, 2016 in the dependency action. To be clear, defendant J. Hatch cannot be held responsible for court orders in the dependency action.
So to be clear, does that mean I'm going to have to start arguing and having evidence on relitigating the DCF and things and bring in people about whether it would have made a difference in the 30 days earlier? Because, I mean, we're opening the can of worms that you didn't want to open.
It's a can of worms that was opened in the summary judgment orders. It's been read multiple times. It's been known to the defense that this was an issue.
It's been known to me what we were going to try the case on, that we were not going to try the DCF case based on orders that were entered long before this trial began, Your Honor. And
His
now,
testimony is in the hospital.
Time out. Can we just have one at a time, please? Count 20 has been limited to the time period prior to November 17th.
So the question, Your Honor, I think is, can Ms. Salisbury or some other lawyer get on the stand and opine as to what she would have done if she had been technologically capable of opening this when she claimed she couldn't, and what arguments she would have made, what arguments the DCF would have made, because John Hopkins wasn't a party, wasn't even attending those, and what ruling the judge would have made. We're stacking a whole bunch of circumstantial things together that looks to me like we're going down a black hole.
Well, I mean, anything after November 17th, we're not going there.
Yes.
That's clear. Count 20 specifically talks about the video surveillance.
Never really alleges that Ms. Salisbury would have done something different in that time period, to my recollection. It was very unclear what they were going to do, or that what they didn't do in reliance on the fact that they didn't know about this.
Well, I guess the best I can say at this point in time is count 20 prior to November 17th is a live count in this case.
I'm sorry, Nick was talking in my ear one more time.
It is a live count. I mean,
Yes.
I guess, again, I guess we have to wait till see whether they put her on the stand, but if we do that, it kind of changes what I visioned the scope of this to be as we were entering in it through pretrial.
I prefer to just take it one step at a time. If I'm understanding the court correctly, the last sentence was that the count remains alive.
Well, count 20 still is a live count to the extent it's prior to November 17th. Now,
That's fine.
I'm going to reread the instruction one more time and see if there's any more tweaks that we need to give. The videotape that the jury has been seeing most recently this morning was provided to the Kowalski's family attorney on November 17, 2016. The jury is instructed to disregard Mr. Kowalski's statement that the video would have made a difference to the extent that such statement applies on or after November 17, 2016 in the dependency action. To be clear, defendant Johns Hopkins All Children's Hospital cannot be held responsible for the court orders entered in the dependency action. Any other?
Yes, Judge. Technically, it would be the prior attorney, so I don't want to diminish my standing before the jury. So rather than saying her attorney, can you say her prior attorney? Or prior counsel?
Or the family's attorney at the time.
Yeah, the family's attorney
I
at
don't-
the time.
How about the Kowalski's family attorney in the dependency action?
Right.
Perfect.
But by the 17th, did they have separate lawyers? I don't know when that at one point, and I think it's before the 17th, he had a lawyer and she had a lawyer. So there were two separate, I mean, he's testified to 4 lawyers, and that's what he's talking about, is that they ended up having 2 different lawyers pretty early on.
And Ms. Salisbury represented who on the 17th?
I think Jack Kowalski.
I think that's correct. And there was new appearance for Beata Kowalski.
So,
In fact, I can,
so why don't I just say to Mr. Kowalski's family attorney in the dependency action on November 17th?
That's
I
fine.
think I may have the answer to this. Hang on.
Mr. Altenberg, any other?
No, Your Honor.
And Mr. Anderson, did you want to say anything on the mistrial motion?
Judge, the error, and we're not conceding there was, but if there was error here, it certainly did not go to the point where it would so prejudice the jury in their review, particularly with the instruction, which I think cures anything. I would simply point out that this case is incredibly complex and difficult to try. for anyone, and I'm sure with the court too, with the number of orders in limine and summary. We have 52 summary judgment orders, and I've lost count of the number of orders in limine. I believe in this case that there's going to be more than one incident where a question brings out something, no matter how much the plaintiff's counsel instructs witnesses, including their client, no matter how much we instruct them, they're human beings. And they don't go as programmed a lot. So my concern on these motions are that the defense wanted them entered, and now we should have some understanding of the difficulty in this case, and that really at this point there is completely insufficient problems to impress this jury to the point where they cannot receive a fair trial, particularly with the instruction.
Anything else, Mr. Shapiro?
Very briefly, the reason for the mistrial is not simply a violation of a motion in limine. It's intentionally walking a witness through questions that knowingly we're going to end with a response that if only something was given to me, the dependency action would have turned out differently, implying that All Children's is responsible for taking Maya Kowalski away. I believe this is the third time that the court has had to give a curative instruction to this jury in this short trial that we've already been through, telling this jury All Children's is not responsible for Maya being taken into state custody. And so it's the cumulative effect of all this. It's not just merely a violation of a court order, but we believe at this point the intentional walking a witness to a statement that this court's instructed multiple times is not a subject to the litigation because we do have immunity. Thank you, Your Honor.
I categorically deny.
Time out. I'm going to deny the mistrial motion. I will say, honestly, I think that the trial has been cleaner than I anticipated it was going to be by this time. Honestly, and that's a tribute to the lawyers. And I think the credit needs to go to the lawyers. The concern I had when that question was raised, which has been articulated by Mr. Shapiro, is the impression it gave to the jury that somehow this video would have caused none of this to have happened. And I think that this curative instruction specifically and directly addresses that perception that Mr. Kowalski's statement could have been given to the jury. And it's done timely, it's done right away. And so I don't see a basis, I don't see a cumulative basis for a mistrial. I'm comfortable with this curative instruction, and I'm confident will ensure that this jury does not take a false implication from Mr. Kowalski's statement. Okay.
Well, yes, Your Honor.
I'd really like to bring the jury back in.
And I really want to not get another mistrial motion, so I wanted to ask the question. The question that was coming next was this, would this video have been of value to you? And he knows not to say anything about substituting it in or reopening the proceedings. But there are two things it's good for. The first is for him to understand what was going on with his daughter, and that goes secondarily to the damages in terms of emotional distress and so forth.
Well, I'm assuming that you are restricting your question to a date range to which it applies. Yes.
Right.
And Your Honor, just to make something clear in the record, I've checked my personal notes, having read the transcripts in the DCF proceedings, and it appears that on November 10th, Ms. Salberry appeared for both parents, and then on December 5th, they each had separate counsel. So sometime in between there, and I cannot tell you whether it's before or after the 17th, that there was a substituting of counsel. I can actually look at the docket on that and figure out the data.
I don't think for purposes of the curative instruction it matters.
I don't think so either. I just wanted to be honest about that.
I appreciate that, Mr. Altenburg. Anything else, or can we bring in this jury?
Nothing else from
And let me ask, how much longer do you have in direct? Because you told me yesterday it was 1 hour.
Yeah, yes, Your Honor. It's been a really difficult extended hour. I would say I'll never finish by lunch.
Okay, so we're going to go to lunch while he's still on direct?
Yes, sir.
Okay.
And I can ask that would have been of assistance to him. That question. It's going to be objectionable. He knows. He's going to touch that again if you like. But it would have been of assistance to him in knowing your legal opinion.
Okay, please be seated, everybody. Okay, members of the jury, I want to confirm while you're away, you did not discuss this case amongst yourselves, you did no investigation, and you received no information. Is that all correct? Correct. And that you did not look at any media coverage concerning this case while you were on break? Correct. And no one approached you about this case, is that correct? Correct. Okay. And members of the jury, I'm going to give you another instruction at this point in time. The videotape that you as the jury have been seeing most recently this morning was provided to Mr. Kowalski's family attorney in the dependency action on November 17th, 2016. The jury is instructed to disregard Mr. Kowalski's statement that the video would have made a difference to the extent that that statement applies on or after November 17th, 2016 in the dependency action. To be clear, defendant Johns Hopkins All Children's Hospital cannot be held responsible for the court orders entered in the dependency action. You may continue, Mr. Anderson.
As the court has related, the video was taken October 18th through 20th. Now, on or before that date, did they tell you in any way, shape, or form that they intended to do a video surveillance in a separate room of this nature?
No.
And if they had, would you have consented or not consented?
I would not have consented.
Did the hospital tell you at any time in October 16 that they had taken a covert video of your daughter over 48 hours in mid-October?
Objection, Ms. States Evidence.
Overruled.
No.
If the hospital had told you about the video before November 8th and 10th, what would you have done in terms of objection? Would you have objected to this video going outside the hospital?
Yes.
All right. So in reviewing this video, when you finally did get to view it, did it affect you emotionally to see this happen?
Yes.
And knowing your wife, would it have affected her?
Definitely yes.
Okay. Now, let's continue, if we might, on the lesion photographs. We were at 2571-001. All right, you recognize this photograph?
I do.
And what is it of?
It's a lesion.
Approximately when did you take this photograph?
There's a date on the bottom, 10/8/2016.
All right, let's go to 2571026. All right, so 2571026, what is this a photo of?
It's a photo of Maya. And there's some lesions. I see one on the forehead and maybe on her left knee there.
All right, let's go to 2571-030. And what do these reveal?
There's more lesions, right and left hand, and then also her forehead.
So this is as of December 24th, before Christmas?
Yeah, Christmas Eve of 2016.
2571-053. So this is of a date some, what, 2 weeks before, no, a week and a half after?
Yes,
And is this the same lesion, unhealed, that appeared in the prior photo?
that is correct.
How long would it take a lesion to heal if they did?
Objection, foundation, call.
He can observe.
Overruled.
I honestly don't know how long it takes to heal. I think Dr. Chopra mentioned that, but I'm unaware.
And then let's look at 2603. And that one is from, looks like, well, that's date of admission. Do we have a date on this one? Yeah.
It's January 1st.
2017. It's in the handwriting.
So, there you go.
That's another lesion.
Okay. And we'll ask about that in a moment. And then 2604. And is that another lesion?
Yes, it is.
All right. So the lesions that you saw there, were they in existence, to the best of your knowledge, prior to January 7th of 2017?
Objection to the leading, Your Honor.
Overruled.
There was lesions. I did document it in my notes, along with taking some pictures and also advising the staff.
Okay. I'm informed 2604 has 8 photos. Let's continue on with those. Now, that last photo and this photo, looking at the pants and the situation, do you know who took these photos?
I was going to say that's not mine.
Okay.
I don't believe so.
All right, continue. And continue. And is that a lesion on her hand?
That is a lesion on her hand, yes. Left hand.
All right, continue.
Lesion on the forehead.
Continue. Now, are you familiar with this photograph?
Recently, yes.
At the time, did anyone tell you that they were going to take off some of your daughter's clothing to try to check her for lesions?
No.
And the prior two photographs, having seen this one, were they photographs of your daughter in this series?
Yes.
Continue to the next one. Well, first, do you see, you can only see half of her face there. But knowing your daughter, what is her reaction here that she's showing?
It's hard to see her whole face, but looking at her lips, she doesn't seem happy with what's going on here.
All right, next photo. And now she's down to what, a training bra?
That is correct.
So, did you ever give Kathy Beatty or anyone at Johns Hopkins All Children's Hospital permission to strip your daughter and take photos like this?
No.
Next, please. Is that the last?
That's the next one.
Okay. And then, did we cover 2603 and that was 2604?
This is 2604 dash 8.
All right. So, make sure we've got them all in. When was the first time you learned that your daughter had had this happen to her?
It was around the time after, I believe, she went to court in December or January. I don't know exactly what month.
Okay. Did it turn out that this was the day she was to go to court?
Yes, it was. She was going to be evaluated by Dr. Duncan.
And again, did anyone call you and ask you about this?
No.
Let's show the remaining photos in 2604. Continue. Continue. Now, hold on there. Go back. Do you notice her hand there?
I noticed her hand and then also the arm. You could see discoloration in it. If you go back one more picture, I believe it shows the arm. See that by the elbow area?
And what did that correspond to with your experience with your daughter?
We were told that's a typical sign of CRPS.
And let's go back to the hand. Next photo. And the next photo. Continue on. Do you know if these were taken in her room or someplace else?
I was somewhere in the hospital.
Continue. See the knuckles? Let's go back a little, and that one too. You have a lesion there right below the knuckles.
That is correct.
Are the knuckles red?
Yes.
Tell the jury what that indicates to you, knowing what you know about your daughter's condition.
Another sign of CRPS.
When she had these, did it indicate that she was having a flare-up?
Objection, called foundation.
Overruled.
A flare-up and associated with these lesions, there's extreme pain to the lesion itself.
So when someone would grab her hands in these videos, can you tell the jury the reaction you have seen your daughter have when they touch those lesions?
It would cause extreme pain.
Next photo. Notice the knees.
Yes, I do.
What does that tell you?
If you didn't know that she had CRPS, you might think they were rubbing against something, but that's a sign of CRPS.
Right. Next photo. And what does that indicate?
That's inward rotation on her feet. That's called dystonia.
Next photo. So here they are pulling up her shirt. Did you ever give them permission to touch your daughter in this way?
No.
Next photo. I can't tell anything about this one. Is there anything we should be looking at?
Not that I see.
Let's continue on.
It's the final photo of the exhibit.
Now, having looked through the photos, can you tell the jury your reaction the first time you saw these?
Okay. I was extremely upset. She's in the hospital. Later, I found that it was against her will. That Kathy Beatty stated that that's the only way she's going to go to the courtroom is to get the pictures taken prior to her.
Objection to the hearsay, though.
It's party admission. Overruled. Did Kathy Beatty say anything about that you know about whether Maya would be able to see her mother?
That I don't recall.
We should ask Maya on that one.
Yes, ask Maya.
All right. So they're talking about these symptoms, not these symptoms, but they're talking about, strike that. Did they ever discuss with you their belief that your daughter was suffering from some sort of psychological disorder?
Objection to the foundation, the they.
Let's be a little bit clearer with our pronouns.
Did any of the psychological or psychiatric doctors there tell you that they believed your daughter had some psychological problem?
Yes.
And who were those, do you recall?
am very bad with names with doctors.
Let me see if I can. Okay. Did it come to pass that you were trying, well, once you heard this, did you want to talk to them and question them about it?
I tried at one point to talk to the Dr. I'm going to bosh her name, I'm sorry, Kattenstein.
That's it.
I did see her in the hallway. She approached me. She was nervous. She was looking around. She says, I should not be talking to you. I would like to talk to you, but I should not be here. And she's looking around. And she said she has to talk to both sides of both attorneys before she could talk to us.
Well, was your daughter in part under the care of Dr. Katzenstein?
She was, and I still had my patient rights.
And so,
Or not
did she ever
patient
tell
rights,
you?
rights for my child, I'm sorry.
Did she ever explain in any way, shape, or form why they thought that this was occurring, or what reasons they had?
She didn't explain it to me. She was just nervous, looking around. She did provide me with her card with her cell phone number on there. But she instructed that, or it told me that she has talked to both sides before she could talk to me.
Well, who's the other side? Do you know?
Well, it would be my legal, Deborah Salisbury, and then the hospital side.
Okay. Now, did any of the other physicians, strike that, who brought it up first to say that Maya was somehow faking this?
That'd be a good question for Maya, because Maya was told by many people.
In the hospital?
Yes.
All right. Did it come to your attention that the nurses there were telling her that she did not have this?
Yes.
Did you learn that Maya was having difficulties even speaking to her separate counsel now, having difficulty speaking to her separate counsel?
Yes.
What was the problem there?
Normally, I don't want to get stuck with hearsay here.
Well, you give it a shot. I'm sure they'll let you know.
Yeah. She advised me when she was speaking with her attorney, Kathy Beatty, be outside the room with the door open, right next to the door.
Right. And during the attempted phone calls with Maya and between Maya and your wife, were you witness to or in the room when Ms. Beatty would, not the hospital room, but I'm talking about more at home, when Ms. Beatty would interrupt?
Most of the times, no, I was not. I did hear from Beata, and I also heard from Maya that was an issue.
And what was the problem?
Foundation and hearsay.
Sustain that one.
And so were you having difficulties communicating with Maya, best of your attempts, because of Ms. Beatty?
I had difficulty, but I didn't have as much difficulty as Beata did.
And how is that affecting her, not being able to, or having her attempts to speak with her daughter interfered with?
It destroyed Beata.
So now, you previously testified that Ms. Beatty asked you, or suggested to you, or asked to you whether you should just divorce Beata?
She asked me if I ever considered it, which was a very odd question, just come up with something like that.
All right. And have you since learned that Ms. Beatty took your daughter to the chapel there at the hospital?
Object to the hearsay, Your Honor.
It's in evidence.
Madam Court Reporter, can I have that question back, please?
Question, all right, and have you since learned that Ms. Beatty took your daughter to the chapel there at the hospital?
It's in Beatty's depot.
Well, I'm not sure where it's coming from, so I'm going to sustain the objection. You can see if you can get it a different way.
Did your daughter ever tell you that Kathy Beatty took her down to the chapel?
Same objection.
No, that's a statement of present condition.
I'm going to overrule that.
Yes, she has.
And did she tell you what the purpose was?
She stated that they went in the chapel and Kathy Beatty would talk to her in there.
Talk to her about what?
Same objection, hearsay.
Overruled.
There was one point that she said that she could adopt her, that she could be her mother while she's there at the hospital. Just all different things. Mom's in getting mental health, help, I'm sorry. Just all different things. Stroking her hair, kissing her.
Did Maya complain to you that Miss Beatty was hugging her inappropriately?
Objective hearsay.
Statement of then present.
Can I have that question again, please?
Question, did Maya complain to you that Miss Beatty was hugging her inappropriately?
Okay, I'm going to sustain that one.
Did you understand from Maya that Miss Beatty was making Maya believe some, strike that. Did it come to your attention that other employees besides Miss Beatty were making similar statements?
Object to the hearsay.
Didn't it?
I agree with Mr. Shapiro on that one.
Now we'll ask Maya. All right. So what you testified to before, just now, about the chapel and the things that she said, did you let Piata know about that?
Yes,
What was the effect on your wife?
she was
when
irate.
To what?
She was irate.
So this was, I think, the photo show towards the end of Maya's stay, and also the record reflects that your wife took her life the evening of when?
It was January 7th, January 8th.
So these photos were taken, were they taken in close approximation to?
Very close.
Objection, Your Honor. Foundation, and I would approach on this, rather than speaking objections.
Objection sustained.
During some of your visits, did you see Maya being mistreated?
No.
Did you see
Not
the
that I know of.
nurses taking any action that you would describe as cold or unusual?
No, there was just incidents where I wasn't allowed to leave a computer, or they wanted her passwords for her social media, things like that. Nothing physical that I could think of. There was a nurse that she liked a lot, but I didn't see anything. You know, I felt that they were cold to me because the situation, like I felt like I was a bad person when I walked in there all the time.
And so now, when you learned of the various things the hospital was doing in terms of the photographs and the video, did that cause you mental distress?
Objection, foundation of predicate.
Overruled.
It sure did.
And can you describe it to the jury why this was so upsetting to you?
It's so upsetting because I have to go home, and then that's happening, and there's nothing you could do. If I snap, I'm going to lose my privileges. It was very difficult for me to hold it in.
Again, object and move to strike based on the time frame.
Now,
Overruled.
did you tell Beata about this?
I did.
Objection, again, hearsay and the time frame again, Your Honor. This is,
Obviously, it's from the high school.
Well, let's try to be better with our pronoun usage.
Did you tell Beata about what we just talked about when I said this, the photographs that had been taken of her, the video that had been taken of her?
same, objection, misstates evidence.
Okay, overruled. You can answer that.
Yes, I did. I did tell her.
And what was her reaction that you saw?
Same objection.
Overruled.
She had the same reaction I had. As a parent, I think any parent would have that reaction.
Did you feel powerless?
Yes, I did.
And how did that translate in terms of your behavior?
My behavior, I was very upset at home, but when I went there, I had to hold it in.
Are you by nature a fairly stoic person?
I'm usually very calm.
You try to hold things in?
Yes, a lot's held in.
How about Beata? Was she that way?
Not as much as me. She would let you know how she feels.
And then when you told her, can you describe for the jury that mental distress that you observed, everything you saw, heard?
Objection, hearsay, predicate, and foundation.
Overruled. You can answer.
I'm sorry, could you repeat it again?
From everything you perceived about your wife, how upset was she when she found out that her daughter was being treated this way?
Same objection, Your Honor.
Overruled.
It was extremely difficult for her. It was taking all the air out of her balloon. I mean, you could see that it was just eating at her. She lost a lot of weight during this time.
Through the course of December, how was Beata doing? Was she stable, not stable, moving down, moving up, what?
Beata was still functioning what she had to do, but it was really difficult for her.
How were you two getting along?
Oh, it drove a wedge between us. I'm trying to, to do both, go to the hospital and then try not to bring it home and tell her everything, where it would hurt her. I'm not intending to hurt her with the way her daughter's being treated, but she needs to know.
Well, did she pump you for information when
She would ask me, and then at times I believe she was talking with the hospital as well, but not getting full answers on treatments and that. So that would interfere and make it worse for her as well, stress-wise.
Were you worried about her mental condition through this period of time?
I was always worried about her. Yeah.
Over this period of time, now we're talking about after you learned about the video 18th and 20th and these photographs, did you have some physical symptoms from this distress?
Objection again to the time frame, predicate, foundation.
I just said it.
Okay. Well, let's be a little bit clear about the time frame, but otherwise overruled.
After you learned of the November 18th to 20th videos and the photographs that were being taken of your daughter and of the manner in which she was being treated overall, Did you have any physical signs of distress?
Same objection, Your Honor.
Yeah, overruled. You can answer that.
Yes, I did.
Tell us what they were.
Number one, anger, loss of sleep, just wasn't myself. Diarrhea. I mean, it takes a lot out of you, the stress.
What happened to your weight?
Same objection, Your Honor, for time frame.
We're talking about this. Are we talking about in the same time frame?
That is correct, I believe.
And then, did you experience in this same time frame we have defined any symptoms of nausea?
I had nausea. Like I said, I had diarrhea. When I get a lot of stress, it's hard for me to digest food, things like that as well. Sleep, lack of sleep, big time.
Tell us about the sleep. Like, how long do you usually sleep without this level of stress? Compare that to what was going on at this time. That is from the period of your daughter going in and after you learned about the video and the photographs.
Later at the end, it was a lot less. I was extremely stressed out. I was concerned for Maya. I was concerned for Beata and Kyle. Knowing Beata was still trying to do research and things like that, she was up more, and sleep and being nervous and things like that was extremely high.
And then there was the evening that Beata took her life.
Yes.
Before we get into that, I'd like you to explain a little bit about the billing that was going on by Johns Hopkins who was your health insurer at that time?
At that time, I believe it was Aetna Insurance, and that was through Beata's work.
And then did you ever have the opportunity to go over these records to see what they were, obviously, what you were being billed for these services?
Predicate and foundation and time.
Overruled.
At that time, Beata managed the bills, but she would inform me that they were astronomical.
Mr. Anderson, just in the next 10 minutes or so, let's try to find a good breaking point for lunch.
With the court's permission, I'll just end with this Aetna billing. Just a few more questions.
Whatever you want, just within the next 10 minutes.
Right. All right. So when was the first time you had an opportunity to go through that billing? Best of your memory.
Well, after she passed, I had to go on to Cobra through her work. And they allowed me to...
I think everybody knows, but what is Cobra?
Cobra, it's just I was able to stay on that program for a certain time period with the same benefits, but I would have to pay in place of the employer paying most of the premium. So it jumped up significantly.
You remember approximately how much?
I'm guessing it's probably in the area of $1,300. I could be wrong on that.
A month?
That is correct.
And have we put those records in evidence?
Yes, whatever I had and obtained, I gave to you guys.
Okay. So then, did you learn that some of the, or most of the entries there, strike it, how did you learn that most of the entries there were for CRPS?
Objection, foundation, predicate, and the state's evidence.
You already said. Did you review the records to see what exactly you were paying for through Aetna, or what Aetna was paying for you?
After some time, there was some for charges for CRPS during that time period.
And did you ever determine what percentage of those billings were for CRPS.
I don't recall the percentage.
Okay. All right. And so what happened then after or during this period of time, every time that they billed Aetna for a procedure that they did not do, did that go on your deductible?
Objection, argumentative.
Overall.
Yes, it did. And then eventually it was, we met our deductible, unfortunately, with all the bills.
And did you have to pay in after that?
There's a lien still today on
How many?
some bills. I honestly don't know, but it's a significant amount of money.
That you owe and on some contingencies?
Objection, it's both leading the state's evidence. Sustained.
We'll come up with something on that. So once the deductible was reached, did you have to pay out of your own pocket the co-payments?
Once the deductibles met, no, I don't believe at that time we had to pay unless, if you're talking about a copay, something small,
Yes.
I believe we had something, but
All right. Approximately what was a copay per visit, approximately?
I honestly wouldn't even know.
Okay. All right. That evening, well, let's break for that.
So lunchtime?
Lunchtime.
Okay. Members of the jury, I'm going to excuse you for lunch. Deputy Coley, I want them back, ready to go at 1:45. So from this moment, you get an hour and a half, okay? Do not discuss this case amongst yourselves. Do no investigation and receive no information. Have a good lunch. See that the jury is out of our presence. Okay, let's work backwards on our time for lunch. When you all come back from lunch, Mr. Anderson, I'm going to want to know what, if anything, you want to do relative to filing your mistrial motion or not on the issue of the sexual abuse claim that I did not allow in.
Yes, Your Honor, I wanted to wait till the break. So we do, and we asked the court not to, and to withhold, obviously, in light of all the circumstances, but we
Well,
would move.
I want to have that discussion after lunch. So tell me, I need to know how much time you're going to need to.
I'm just going to make the motion and just explain what it is. I won't need more than 5 minutes.
Okay. And are we having any exhibit issues that we need to address?
Let me check. Do we have any exhibit issues we need to address?
We're planning 2 depositions when Mr. Kowalski's done.
How long are those depositions?
One of them is about an hour and 20 minutes, and the other, I don't know, maybe someone just watched Ms. Beebe?
No, we haven't had a chance, I don't think, to watch it. We'll do it over lunch.
It's a little over an hour.
Both are a little over an hour, I'm told.
That's aspirational only because I probably have at least an hour of cross. So,
Well,
anyway.
and on the videos, this is the first time, and as I said before trial, but I want to remind you, you're going to have to tell me time frame. Let's say the video is an hour. I need to know how much is attributable to the plaintiff and how much is attributable to the defendant. And I don't want to have an hour discussion as to how to divide up the hour time. So perhaps.
I'm sorry, didn't mean to interrupt.
Yeah, so make sure you're ready to give me that split.
Okay. I guess we'll try to stopwatch it, but the problem is the speaking objections through it, as the court's no doubt seen, add a lot of time.
Well, we'll know it's an hour and 30 minutes or whatever it is, and I need, to a 5-minute increment, a division of that, the amount that we're going to play for the jury.
Yes, Your Honor.
Okay. Anything else that we're going to have to do?
Not from the defense, Your Honor.
No, Judge, I don't believe so.
So if we are back here at 1:30. That would give us 15 minutes. Is that going to be enough time to address these issues?
Yes, Your Honor.
I believe so.
I will see everybody at 1:30 then.